Oh, that's why it feels so cold. Power went below. Better get that off the screen. That's kind of funny. It's saying, oh, it says multi-speaker activates for 5 or more participants.
Yeah.
That's what you're saying. Okay. I'll see how I like that.
A lot of people joined, so I'm gonna open up, let them
Okay.
in the hearing room.
Oh, it's just you.
Oh, that might change. So you didn't pop up now that you spoke? No?
No,
Are you on?
I did.
Hmm. Gallery should work. It's working for me.
Gallery is everybody.
Gallery, right. Gallery, and then multi-speaker should put people on the bottom and the speakers on the top.
Yes. But I only have you on the top because obviously you're the one speaking. So maybe once people start speaking, they'll go on top.
Maybe
If
can you
it,
make your screen bigger? Maybe it's cutting you off because I'm on my screen, even though I'm not talking all the time.
but nobody's. Oh, I should be up
I
there,
have
but
you
I'm
and
not.
me at the top.
Hmm.
I don't know why it's not working.
Can somebody else just say hello, good morning?
Good
Hello, good
morning.
morning.
Hello,
Extra
good morning.
points, extra points.
They're
Maybe
not moving.
it might take a little bit more than just one word. Yeah,
How are you today?
Oh, just peachy.
we're working on it.
Today I have ice on my back.
What?
I said, today I have ice on my back.
Oh,
Nice.
ice? I thought you said mice.
Oh,
Oh
nice.
my God, I wouldn't be in my house. We'd be doing this in my driveway. Are you kidding me? Of course, that would probably be worse, but my dogs might catch the mice.
Ooh.
Oh, it's 9 a.m. I'm going to go back to the whole big view.
Yeah, I'm still checking people in, but uh,
Okay.
so we're just
I'll mess with that as we're going along. That's why it's white back here. Got to get rid of that white stuff.
Morning. So, Your Honor, and Mr. Singletary, we kind of slept on it overnight and don't think we have any cross for Mr. Kine. So from our perspective, he could submit by affidavit, but I know it would probably be easier to have him affirm live in the hearing.
Okay, thank you for that update.
Yep.
And then, Your Honor, I don't know if we wanted to wait until you're sure we had everyone here. Late yesterday, when we were just double checking stuff, we realized that we mistook on your offered evidence list the second line under Singletary Direct. I think it's the public version for what we thought was the errata. We had submitted some very, very, very tiny errata to Direct. And I was going to make note of it on the stand today, but just didn't want to surprise you with that item.
Yeah, thanks. That was to your direct, you said?
Correct. And I can get you the ERF number if you need that.
If you have it, you might as well. That's great.
Yes, it's 536341.
So it looks like we have everyone in attendance. Why don't we get on the record? Welcome everyone back to day 2 of the party hearing session in docket 6630 CE 317. I'm Michael Newmark, Administrative Law Judge for the PSC. Let's just do appearances quickly so we know who's here today. We'll start with AEU.
Good morning, Your Honor. Travis Murray with the law firm Keys and Fox LLP on behalf of Advanced Energy United.
Thank you. Citizens Utility Board.
Good morning, Corey Singletary on behalf of the Citizens Utility Board. I'm also joined by Dr. Steve Keim.
City of Milwaukee.
Morning, Your Honor. Assistant City Attorney Tom Miller for the City of Milwaukee.
Clean Wisconsin.
Morning, Judge Newmark, Brett Cordy on behalf of Clean Wisconsin, and I'm joined by Katie Nicola.
Right. Healthy Climate Wisconsin and Union of Concerned Scientists.
Good morning, Judge Newmark, on behalf of Healthy Climate Wisconsin and Union of Concerned Scientists, Grant Snyder of the law firm of Keys and Fox LLP.
Public Service Commission.
Good morning, Your Honor. Stephanie Bedford, Assistant General Counsel, appearing on behalf of the Public Service Commission. Renew
Wisconsin.
Good morning, Your Honor. Sharif Halawish for Renew Wisconsin.
Okay, and your mic is a little low. If you're going to be speaking, just you want to check that for the record.
I have it on my paperwork, but who are you for again, Mr. Halawish? Oh, Renew, it's on the screen. Forget it. Thank you.
Sierra Club.
Megan Walkspress on behalf of Sierra Club.
Okay. Scroll down here. Walnut Way.
Good morning, Your Honor. Attorney Eduardo Castro of Pinesbach LLP appears on behalf of Walnut Way.
WEPCO.
Good morning, Your Honor. Attorney Patrick Proctor Brown, and with me are attorneys Wilson, Phillips, Rosso, Gutner, and Fortune. Attorney Goldschmidt is on the list, but he's not here today.
Okay, thanks. And Weeg.
Good morning, Your Honor. Attorney Steve Heinzen for the Wisconsin Industrial Energy Group.
They're usually last. How about
that seems to be the case, yes.
But not this time. Wisconsin Local Government Climate Coalition.
Morning, Your Honor. Matt Frank for the Wisconsin Local Government Climate Coalition.
Okay, great. Look, everyone's here. Thanks for joining us on our second day. I think we could get started. I think there may be some changes are expected with who we need to cross. Or who there may be cross for, but I did want to mention there's one witness that I think had a time constraint that I'm wondering if looking at the list, that they may actually look like we would be calling them around that time. It would be witness Jester. Looked like that person was available all today except for between the 2 to 3, the 2 o'clock hour. Just looking at the list, I'm wondering maybe we would be hitting the 2 o'clock hour right about that time. So are we prepared? Can we take Jester now, or is there any issues with that?
We would be prepared, Your Honor, if that's what you prefer.
Okay. Yeah, since that time constraint looks like it may be the one that may give us some problems, let's do Jester now, and then we'll continue with the regular schedule.
Your Honor, also, Commission Staff Witness Tomaszewski has the same time constraint as yesterday. He's going to be in our training until noon, so if we can take him after noon, that would be optimal.
Okay, yeah, okay, so after 12, yeah, I think
That's correct.
we'll be, yeah, and we can be probably more flexible with him as well, so that's okay.
Thank you.
All right. Okay, so not seeing our witness yet.
Sorry, Your Honor, yesterday there was potentially a time constraint for Dr. Nunez. Is that still the case?
That is still the case.
Yeah, I just didn't think that would be.
Okay.
Let me just check.
I'm sorry, was that Mr. Wilson speaking?
Yes, it was.
Yeah,
Okay.
let's go off the record. Sorry that I didn't know we'd have more. 12 to 4. Oh, I didn't see the 12 to. Oh no, okay, only avail. So I think there'll be time. That's a big enough time. So they're available between 12 and 4. So that's just something we have to work in. Hopefully, yeah, we'll just have to move other people around if we have to. But
All right, no issue from our perspective. Just
Okay.
want to verify for planning purposes. Thanks.
Yeah. Okay, got it. And I'm going to change my screen. It's
my fault.
Well, it was working before. Okay, so let's just find witness gesture. I haven't seen him yet. He's not, I mean, if there's a problem, we can just continue with the regular.
Your Honor, I am here.
Oh, okay. Do you have a screen video camera?
Just turning it on.
Ah, perfect. There we go. That was the problem. All right, so get you up there. Why is it doing full screen? There was a Zoom update, unfortunately. There we go. All right, great. Let me swear you in. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Go ahead, Attorney Cordy. And you're muted, by the way. So you know. We're on the record.
Thank you, Your Honor. Good morning, Mr. Jester. How are you today?
Very well. Good morning.
Could you please state your name for the record?
My name is Douglas Jester, Jester.
Mr. Jester, are you the same Douglas Jester that prepared and caused to be filed direct and surrebuttal testimony and associated exhibits in this docket?
Yes.
To the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes.
And do you have any corrections to your testimony that you would like to make on the stand today?
I do not.
Thank you, Mr. Jester. Your Honor, the witness is available for cross.
Okay. I just wanted to confirm it's 11 exhibits filed by Jester.
I can confirm. Yes, 11 exhibits.
Okay. Yeah, I may have missed that yesterday, but if people, when they're introducing the witnesses, just give me the name, the number of exhibits, just so I can check and make sure I got everything listed on the offered evidence list. Sometimes it comes up later, even though we've already confirmed the list is correct. Okay, so cross for this witness. Is WEPCO have questions?
Yes, Your Honor. I have some questions for Mr. Jester.
All right, go ahead.
Thank you. Good morning, Mr. Jester. My name is Attorney Patrick Proctor Brown. I believe we met about a month ago in the Paris race hearing. Do you remember that testimony?
I do. Good morning.
Morning. And Your Honor, we've submitted as a cross exhibit the transcript of an excerpt of the transcript from the Paris race hearing. I might refer to that a little bit today.
Okay, thanks for letting me know.
But I wanted to start first with Mr. Arndt's rebuttal testimony, if you don't mind, Your Honor.
Mm-hmm.
I think we start at page 13. Mr. Jester, as Judge Newmark is getting that up, could you just confirm that you've read Jody Arndt's rebuttal testimony in this case?
Yes, I have.
We're going to turn to page 13 of Mr. Arndt's testimony. And beginning on that page and continuing through about page 17 of the testimony, Mr. Arndt is discussing reliability concerns expressed by the North American Electric Reliability Corporation, which is the acronym is NERC, Reliability First, and MISO. Would you agree with that general summary?
Yes, I would.
What is NERC to your understanding?
North American Electric Reliability Corporation. It's a nonprofit organization to whom the Federal Energy Regulatory Commission and its Canadian counterpart have delegated certain authorities for formulating policy and monitoring circumstances related to the reliability of the North American electric systems.
Thank you. Would you agree that NERC's mission is to assure the effective and efficient reduction of risks to the reliability and security of the grid?
Yes.
Would you agree that when I refer to the grid, another term might be the bulk power system?
Yes.
And in certain NERC documents that might be abbreviated as BPS. Would you agree with that?
Yes.
Would you agree NERC is a credible source on the issue of grid reliability?
Yes.
What is reliability first to your understanding?
It is an affiliate or suborganization of NERC, responsible for auditing and making recommendations concerning reliability of the grid in an area on the U.S. side of the Great Lakes.
Would you agree it's the regional organization for the reliability and security of the electric grid under delegated authority from NERC in this area?
Yes.
Would you agree reliability first is a credible source on issues of grid reliability?
Yes.
Do you consider MISO to be a credible source on issues of grid reliability?
Yes.
And without going through these 5 pages in detail, do you have any basis to dispute Mr. Arndt's description of NERC's and reliability first's concerns about reliability in MISO?
No.
And Your Honor, if you could go to page 16, please.
Sure.
So beginning at line 3 and through line 7, there's a bolded quote from NERC that says natural gas-fired generators are a vital grid resource. Do you have any basis to dispute NERC's views on the importance of natural gas generators for reliability?
No.
Thank you. I want to switch gears to energy efficiency and demand response. Is it your position that energy efficiency and demand response are potential alternatives to the 1100 megawatt OCCT project?
To a portion of it.
But not the whole thing?
No.
Thank you. And Your Honor, if we could bring up the cross exhibit.
So I'm just curious, you're calling this an exhibit? Are you planning to offer it?
Yes, Your Honor.
Okay. So probably just call this and you're going to use this for multiple witnesses?
At least Mr. Jester, probably Mr. Goggin. I think it would be multiple witnesses.
Okay. So why don't we mark it exhibit WEPCO transcript, and then we can receive it after if it's necessary, but I don't think there should be any problem with that.
Okay, that sounds good, Your Honor. Thank you.
I just wanted to ask though, in anticipation of filing, so so this was appears to me to be the original that's filed on IRF, the original transcript volume that's filed on IRF, but like you mentioned there, it's excerpts of at least one volume. But the point I want to make is that if you could please, when you file this as an exhibit, remove the certification from the court reporter, because this isn't the exact document that the reporter has verified.
Yep, understood. Can definitely do that. Just included it because it was in the original volume.
Yep. No, I understand that. I just wanted to make sure I let you know about that. detail. Wouldn't be,
Will do.
you wouldn't have expected that. So, okay, go ahead.
But just before we move off that, you're right, Your Honor. It's an excerpt from 2 volumes, the 2 public volumes, just to make that offer of proof.
Oh, great.
So, and Your Honor, the transcript page number is 361. Not sure if you can search for it or if we can just scroll to it.
This will work.
That's perfect.
All right.
Mr. Jester, we have on the screen what we're marking as Exhibit WEPCO transcript, and this is page 361 of the transcript in the Paris Rice docket. Did you review this transcript before it was finalized?
No, I did not.
Are you aware that your counsel at Clean Wisconsin had the opportunity to review this transcript and correct any mistakes in it?
Yes.
And at the top here, I asked you a question. Would you agree that Wisconsin's statewide focus on energy program has been effective? And your answer was, I am not familiar in detail with the focus on energy program. Do you see that question and answer?
I do.
And then a little bit further down, I asked you, what's the reputation of the focus on energy program to your understanding? And you said that it is effective at a modest scale. Do you see that question and answer?
I do.
And in the last month, have you done anything to research the focus on energy program that would change your answers as you expressed in the Paris Rice hearing?
I have not.
Thank you. And so switching gears to kind of general energy efficiency programs, Your Honor, if you don't mind, you could take that down. Thank you. The effectiveness of any energy efficiency program, including the focus on energy program, ultimately relies on the actions of consumers, right, Mr. Jester?
Yes, it does.
Energy consumers need to take action and participate in any energy efficiency program, correct?
Yes.
The utility cannot mandate participation in an energy efficiency program, correct?
As a general rule, it is possible that a utility would mandate participation in an energy efficiency program or require meeting certain energy efficiency standards as a condition for certain tariffs.
And the consumer would have the ultimate choice whether to take service under those tariffs, correct?
Correct.
The utility has to rely on consumers to take action outside their control for an energy efficiency program to be effective?
Yes.
And the commission also can't mandate that consumers participate in any energy efficiency programs, correct?
That's correct.
You would agree that consumers also have to take action for demand response programs to work, correct?
Yes.
Consumers need to opt into a demand response program in sufficient numbers for the demand response program to be effective, correct?
Yes, although again, access to certain tariffs could be conditioned on participation in demand response programs.
But the consumers need to make the ultimate choice to participate in those tariffs and then to take action in response to demand response signals, right?
Yes.
The commission cannot order consumers to participate in a demand response program, correct?
Yes.
Switching gears again to firm demand and capacity planning. Does that topic make sense to you as a general matter?
Yes.
And Your Honor, I'm going to be referring to Mr. Jester's rebuttal testimony, I believe starting on pages 2 through 5.
Okay, the reorient here. Jester. Which testimony, sir, rebuttal?
Yes, Your Honor. And Mr. Jester, are you aware if I refer to a large load to a new customer? Would you have an understanding of what I'm referring to?
For clarity, you're avoiding reference to confidential information in the case.
Yes.
Yeah, then yes, I do understand.
Great. So in your rebuttal testimony here on pages 2 through 5, you discuss that new customers' load projections and contractual commitments. Would you agree with that?
Yes.
And you make some comparisons between the nameplate capacity of the OCCT and Oak Creek CT facilities to the new customers' load forecasts. Would you agree with that?
Yes.
What does the term high load factor mean?
It characterizes customers whose average load is a large fraction of their peak load.
So fair to say that a customer with a high load factor will have a similar demand overnight to their demand during the day?
Yes.
What does the term firm demand mean to you?
It's demand that the utility is expected to supply if called on, typically physically by the customer. There's no arrangement by which that demand is subject to refusal of service, except under emergency conditions.
Right. So you just to summarize what you're saying, when you say the utility is expected and there's no arrangement to not provide service to firm demand, you understand that Wisconsin Electric has an obligation to serve the firm demand of all of its customers. Is that your understanding?
Yes.
Can 450 megawatts of high load factor firm demand be served by 450 megawatts of nameplate capacity?
No, generally not.
Because even a dispatchable resource will have some maintenance and outage periods over the course of a year, right?
Yes.
Can 450 megawatts of high load factor firm demand be served by 450 megawatts of solar capacity alone?
No.
Have you done any analysis to determine the generation and storage portfolio necessary to serve 450 megawatts of high load factor firm demand?
There are essentially infinitely many resource portfolios that could satisfy WEPCO's resource adequacy obligation, 450 megawatts of firm demand. I have not performed an optimization analysis of which of those portfolios would be best.
And so you said you haven't performed an optimization analysis of which portfolio would serve that load best. Does that mean you also haven't performed any analysis to determine how Wisconsin Electric would serve 450 megawatts of high load factor firm demand if the OCCT project is denied by the commission?
The way that the WEPCO is a MISO market participant. As such, WEPCO does not serve directly the demand of any of WEPCO's customers. That demand is served by the MISO market. And it is the aggregate supply of resources in the MISO market that will serve that firm demand. WEPCO's obligation as a market participant is to meet the resource adequacy standards, including that load, by having sufficient resources to meet zone resource credit requirements in each season. And as I was saying earlier, there are a huge number of different resource configurations by which WEPCO could meet that resource adequacy obligation. The simple version would be to take the effective load carrying capacity or accreditation ratio for any one of the technologies and divide that into 450. But no single resource would typically be the right or the best solution to meeting those resource adequacy obligations. It will almost always be a portfolio.
Have you done any analysis to determine the optimal resource portfolio if the commission denies the OCCT project?
I have not.
And you mentioned some obligations in MISO. Wisconsin Electric is also a load serving entity and a load balancing authority. Do you agree with that?
Yes.
So that's their obligation extends further than just ensuring adequate capacity in the planning resource auction and the resource adequacy construct, right?
I think your question is ambiguous. It would suggest that you identify any specific obligation you have in mind.
My question isn't empty. It's there are more obligations on Wisconsin Electric besides meeting the capacity obligations in the planning resource auction and the resource adequacy construct. They have other obligations in the day in and day out energy markets as load serving entity and a load balancing authority, right?
They have obligations to participate in the short-term energy markets. They do not have an obligation to produce power equivalent to the demand of their customers at all times, if that's what you're implying.
I'm not implying anything. I'm just saying you haven't stated all of Wisconsin Electric's obligations in the MISO markets when you talk about participation in the planning resource auction and the resource adequacy construct, right?
To my knowledge, I have described essentially all of the obligations that relate to satisfying 450 megawatts of firm load.
Contained within the MISO markets, right?
Yes.
So Wisconsin Electric also has state level obligations to ensure it can meet, which we discussed earlier, the firm demand of its customers, right?
It has state level obligations, but as a MISO market participant, the obligation to supply power to your firm customers is met by purchasing that power from MISO. 100% of the power supplied to your customers, you must purchase from MISO.
I think we'll agree to disagree that you stated all the MISO obligations, but we can move on from that. State in your rebuttal testimony on pages 3 and 4 that the generation capacity for which Wisconsin Electric requests approval in this case, and I'm sorry, I have this a little bit wrong from the Paris Rice plant application totals 1,314 megawatts. That's the answer right there.
So it looks like you're pointing to page 3 of the rebuttal, line 19. Is that
yes?
Give your location.
Do you see that testimony, Mr. Jester?
I do.
And you go on to say, I believe, 1,314 megawatts is substantially more than Microsoft's announced requirement for 450 megawatts for phase 1 of its data centers, and material more than the demand referenced in the new customer's current contract with Wisconsin Electric. Did I summarize that testimony right?
Yes.
Are you referring to anything other than a comparison between nameplate capacity and these two measures of the new customer's demand?
Not explicitly, no.
What is capacity factor?
Asked and answered.
Asked and answered?
Yeah, he had him answer that question at the top of the cross.
No, I don't think they did, but I asked different.
I don't recall exactly. I think it's probably no harm in asking that again in case I'm sure the witness can answer that the same way he did before.
Capacity factor applies to a generation resource and is the ratio of average production to the nameplate capacity of that resource.
Thank you, Mr. Chester. Are you aware of the capacity factor that the US EPA uses to define a peaking natural gas facility?
My recollection, subject to check, is the capacity factor would be less than 20%.
So a 20% capacity factor cap would be consistent with a peaking facility. Would you agree with that?
Yes.
Would you agree with me that a facility with a nameplate capacity of 1,200 megawatts and a capacity factor of 20% is only producing the same amount of energy as a 240 megawatt?
I'm sorry. Would you agree with me that a facility of nameplate capacity, go from there,
of 1,200 megawatts and a capacity factor of 20% is only producing about the same amount of energy as a 240 megawatt firm load would require?
Approximately, yes. Mm-hmm.
So that 1,200 megawatt facility with a 20% capacity factor is not generating energy equally across all hours. Would you agree with that?
Yes.
So would you agree with me that planning to serve high load factor firm demand is more complicated than simply comparing the nameplate capacity of generating resources?
I acknowledged that in the Paris Rice testimony, but I'd like to clarify a point. The task for WEPCO to supply energy at all times to such a load is mediated by the MISO market, as I was discussing earlier. It is indeed MISO that would meet the load of that capacity factor at all times. They do so by dispatching a wide variety and large number of generating units. It is not WEPCO's obligation to plan for a single generating unit to serve the load of any customer, let alone a particular customer with a high load factor. So it is more complicated than that, but it is really a red herring to focus on whether a single generating unit meets the demand of a single customer.
It is Wisconsin Electric's obligation to serve the firm demand of all of its retail customers. Do you agree with that?
Objection. Calls for legal conclusion.
He's already answered about this. It's just clarifying his.
I'd like to hear his opinion on that, and we understand. Let me ask you first, witness Chester, are you an attorney?
I am not.
Okay, so under that, with knowledge of that, we can answer your questions based on your expertise that we have identified on the record.
WEPCO, as a MISO market participant, meets the obligation to serve that customer by purchasing a power from MISO. And that power supplied by MISO may come from WEPCO generating units or from generating units owned by other parties, in reality from a mixture of them. So the obligation to serve is met by me being a MISO market participant and by meeting obligations as a MISO market participant rather than by the specific generating units that WEPCO owns and operates.
All right, so that wasn't quite my question. You would agree with me that Wisconsin Electric has an obligation to serve the firm demands of their retail customers, right?
Yes.
Are you aware that NERC has stated, frankly, multiple times at this point, that MISO is at high risk of not having sufficient capacity resources to meet electric demand?
Yes.
So would it be prudent for a load serving entity, a Wisconsin utility, to rely solely on the MISO market to meet its state level obligation to serve the firm demand of its retail customers?
As a MISO market participant under the MISO tariff, WEPCO has no alternative but to rely on MISO to meet the load of its customers.
So that's not quite true, isn't it, Mr. Jester? Their generation assets sell all of their energy into the MISO markets, and then they procure all of that energy back, or other utilities procure some of it to serve the retail obligations to serve for demand, right?
There's no linkage between WEPCO's customers' demand at any given time and the generation that MISO orders from WEPCO's resources.
That's also just factually incorrect. The linkage or the distribution network to the transmission network and back to customers. They're physically interconnected through distribution network.
Okay, you need to frame. Hang on, off the record. Okay, I know it's getting heated, but you need to frame your statements as a question, Attorney Proctor Brown. You might have been getting to it, but I think there may have been some maybe people getting a little nervous about that. But yeah, so if you could.
And I think that's inappropriate, Your Honor, to be honest with you, because literally in cross, I can put a statement to the witness and ask him if it's correct.
Yes,
so the objection that I'm testifying is just totally out of bounds.
Yeah, and that's why I wanted to cut that off.
Thank you, Your Honor.
But so let's get back on the record. Why don't you? We didn't complete that sentence, so I think if you start over, we'll take it from there.
Thank you, Mr. Jester. Would you agree that WEPCO's generating assets are physically interconnected to their customers through the distribution system, the transmission system, and then back to customers? Do you agree with that?
Yes, I agree with that. It is also true of all other generating assets in the MISO transmission system.
In the MISO, in the MISO what system?
Transmission system.
Thank you. Sorry, Mr.
So would you agree on every day in Wisconsin Electric service territory, there are customers that are being directly served through that physical linkage by Wisconsin Electric's generating assets?
The nature of power flow in the transmission system is that the load served at any one point is supplied by power from many sources, and that the load served by any generating unit is relatively dispersed. So there is not a one-to-one linkage between generation by WEPCO generating units and consumption by WEPCO customers. There is definitely power flow. There definitely is power flow from WEPCO generating units to WEPCO customers, but that is only a partial picture.
And Wisconsin Electric has an obligation to ensure that that power flow happens uninterrupted for all of its firm load every day, 24 hours a day. You agree with that?
WEPCO satisfies its obligation to serve by purchasing that power from MISO, and MISO schedules the generating units to serve that load, not WEPCO. That load may or may not be served by WEPCO generators.
So is it your testimony that Wisconsin Electric should shut down its generating assets and rely on the MISO market?
No.
Okay, thank you. Now move on to what I think is the majority of your testimony, which are battery energy storage systems. Would you agree with that?
In terms of link, that may be the majority of my testimony. It is not the central aspect of my testimony.
Okay, and then if I call those resources BESS, you understand what I mean, right?
I do.
And Your Honor, if you could, you have it up, but if you could go to page 8 to 10, that'd be great. So Mr. Jester, in this section, you respond to witness Nicholas. Agree with that?
Yes.
On page 10 of your rebuttal, you acknowledge Mr. Nicholas's testimony that there are costs, complexity, and complexities and risks of third-party arrangements related to tax credits. You agree with that?
Yes.
And right before that acknowledgement, you cite to pages 10 to 11 of your direct testimony for your statement that there are a number of alternative ownership structures that could provide Wisconsin Electric most of the benefits of a BESS investment tax credit. It's in footnote 34. Do you see that?
Yes.
Or, I'm sorry, it's in footnote 35 in this.
You're correct. Thank you.
Have you done anything to quantify the term most used in that sentence?
No.
And Your Honor, if you could pull up Mr. Jester's direct testimony, I'd appreciate it.
If it's here, no.
Thank you.
I'll get to it. Hang on. Okay.
And page 10, if you don't mind, Your Honor.
Putting my keyboard. There we go. Is that right?
I think this moved around a little bit. Sorry about that. There's a section where Mr. Jester talks about tolling agreements, purchase power agreements. I think it might be the next page. Yeah.
12 is where tolling comes up. Yeah.
If I can help, bottom of 12. Yes.
Mm-hmm.
Oh, thanks. Yeah. So I believe you point to three options here: a tolling agreement, a purchase power agreement, or simply purchasing the zonal resource credits from a BESS system owned and operated by a third party. Would you agree those are the three third-party arrangements you're discussing in this testimony?
Yes.
Would you agree that you don't cite to any external authority for this part of your testimony related to those three options?
I agree.
And you don't provide any examples of any agreements related to those three options, right?
Correct.
And we talked about this a little bit in the Paris Rice docket, but you're not able to testify about the amount of profit that the third parties require in any of those agreements, right?
Correct.
And you don't contend in this docket or the other docket that third parties will enter these arrangements without requiring profit, right?
I would expect that they would require profit.
And the second option, you say where Wisconsin Electric would pay for the energy outflow and zonal resource credits provided by the storage system. I don't believe you have any estimate of what that would cost, right?
In your cross-examination of me on this topic in the Paris Rice hearing, I said, and I repeat now, that depends on the terms of the contract, and that I can't answer without more specification.
And as you sit here today, you can't answer any questions about the terms of those contracts, right?
Because the terms of those contracts would be determined by WEPCO's solicitation, not by me or anyone else.
Right. So as you sit here today, you can't offer that third-party arrangement in any specificity, right?
I could offer specificity of an arrangement, but it's for WEPCO to decide the terms and conditions of its contracts, not for me.
And we talked a little bit about zonal resource credits here and in the previous docket. The acronym for that would be ZRC. You agree?
Yes.
And you're aware that ZRCs do not provide any rights to capacity or energy, right?
That's correct. Yeah.
And I asked you this in the Paris Rice docket too. I believe your answer is probably going to be the same, but tell me if it isn't. Are you aware of a BESS facility in MISO Zone 2 that is willing to sell ZRCs?
I am not aware of an existing one.
And did you develop any data at all about the price and availability of these different third-party arrangements?
I did not develop a comprehensive view of data on any of those. There are very few facilities and therefore very few cases. I am aware of some such arrangements and of their prices.
Can you point to any Wisconsin utility that has entered one of these three types of agreements for BESS?
I do not have comprehensive knowledge of the business arrangements of all the Wisconsin utilities. I can't point to any single example.
And Your Honor, if we could go back to Mr. Jester's rebuttal testimony. And it would be at page 12, I believe.
Oh, I could have told you that. I'm reading the transcript as we speak.
Yeah.
There we go.
And your rebuttal testimony on pages 12 to 14, you refer back to Mr. Sieber's criticism of your direct testimony. Is that fair?
Yes.
Mr. Sieber notes that you appear to have repurposed the presentation you developed back in 2022. You don't dispute that at all in your rebuttal testimony, right?
I did use as an example in my testimony work that I did related to a presentation in 2022. That is not the only work on this topic that I've done.
So your answer is, in your rebuttal testimony, you don't dispute Mr. Sieber's characterization of the source of some of your testimony in direct, right?
Source of the illustration that I used in my testimony. That's correct.
And at the time your data was collected, there wasn't a battery operational at that site, right?
Correct.
And I believe you testified in the Paris Race docket that you have no knowledge of any battery operations at that site, right?
Correct.
And you haven't done anything to confirm that your analysis matches the actual operation of the kind of theoretically modest BESS facility, right?
I have determined that DTE that at that time had plans for such a battery facility did not ultimately install it.
Oh, okay. So since the Paris Race docket, you researched this further and determined that the BESS facility was not installed at that location. Is that right?
That's correct. There was neighborhood objection.
And we talked a little bit about your
let's go off the record. Sorry. Just take a. You're okay?
I'm good. Yeah.
Okay. All right. Back on. Go ahead.
Thank you, Your Honor. Mr. Jester, towards the end of your testimony in the Paris Race docket, I asked you some questions about your experience with BESS. Do you remember that?
Yes.
You agreed that your only experience analyzing BESS is a prospective analysis about the hypothetical operations of a BESS facility, correct?
Yes.
You've never operated a BESS system, correct?
Correct.
You haven't done any analysis of an existing BESS system, correct?
Correct.
Your Honor, I think we're moving the transcript into the record. I just want to make sure that we had that discussion on the record.
We have not yet, and I was curious to what extent is it necessary? Because I think we do have the questions and answers on this record. I mean, I don't think he was contradicting himself or had any issues that we need to confirm with the past the 316 transcript. Is there a need to put it in the record at this point?
Well, I'd say he did reference it in his cross testimony. I had him read and verify it. So there were a couple places where I think the record would be incomplete without it. I'm not sure whether I'm going to use it with Mr. Goggin or another witness.
Mhm.
And so I think in kind of the rule of completeness, I think would say it would be useful. I don't know if anybody's going to cite it, but we may.
All right. Yeah, just to complete the record. Sure. Okay. And so, so how about we have you move for admission of the transcript of, well, I guess I'll just ask, in terms of exhibit WEPCO transcript, any objections to receiving that into the record? Okay, I'm not hearing anything. So we'll put that in just to remind you about that certification. You want to remove that page.
Thank you, Your Honor. And thank you, Mr. Jester. I appreciate your time today.
Okay, any other cross for Jester? Okay, I did have there's a couple of issues that I just want to make sure we clarify from Jester's testimony. I think it may have just been the wording of a question that just wanted to catch, because I think the way the question, it was related to contracts, I believe. And it was referencing back on Jester's direct. See if I can find this here. And okay, hang on, let me find it. So before I. Not finding it. So my, okay. Got it on the confidential version. I don't know why it's not coming up on the.
Are you off the record?
Yeah, let's go off the record.
Okay.
My rambling. Certs, maybe it's just this. Okay, so this is one example. So let's get on the record. So I just wanted to clarify, have you clarify for me, witness Jester. There were some questions, I don't know if you recall, let me know, that were asked by Attorney Proctor Brown about contractual obligations between WEPCO and our customer. And I think the way you had worded in your testimony is that the obligations were asserted by witness Stasek. And I think the way the question may have been asked is that there were contractual obligations, and you answered the question. So I just wanted to make sure if you've changed that testimony. And I just want to point out one other point in the testimony where you bring this up.
And Your Honor, it was not my intention to have him discuss the contracts. So if you'd like, I can ask a couple of clarifying questions there.
Well, I can do that. I just wanted to point out one other spot, and it's not. I don't think it was it's not intentional. It's just I think the way the questions were running, it just may. I think he was very careful to say asserting and claiming rather than there actually being these obligations in place. So I wanted to. So I guess with that information, I don't know if there's another spot here.
Also happy to stipulate, Your Honor, that he hasn't changed the assertions in his rebuttal testimony on cross.
Okay. Okay. Okay, well, why don't we?
At least as it relates to the new customer, I would say.
Yeah. Here we go. Okay, yeah, so I think this probably is the statement. I just wanted to make sure that the witness confirmed that's still their understanding. And it's on Surrebuttal Jester 4, lines 10 and 11. So this is the understanding of the witness is that, and I'll quote, Microsoft's public statements that they will pay the cost of the generating capacity required to serve their facilities is not backed by a contract between Microsoft and WEPCO. And the rest we don't need to go into. But is that still your understanding of the situation, Witness Jester?
Yes, it is.
Okay. And then there was also comments about firm service. And I wanted to show you document here and see if that changes your mind or will increase your understanding of the situation. So I do have WEPCO's tariff. It's volume 17, sheet 11, version 2. It's section 102. So under point 1 sub D, and I'll read this. The company will use reasonable diligence to provide, but cannot guarantee an uninterrupted and regular supply of power, and it shall not be liable for interruption, deficiencies, or imperfections of service. So I was just curious, is that when we were having discussions of the firm service in the exchange between you and WEPCO attorney, does this change your anything that you said and answered in response to those questions?
My answer to Attorney Proctor Brown was more colloquial than this, but this is substantively what I meant. The obligation to provide firm service is certainly subject to the physical ability to do so and emergency conditions, and that's what I see 102.1D as describing.
Okay, great. And then further on, I don't know if you could, this didn't come up in cross, but I just wonder if you could provide some clarity for the record, and it may not be maybe just my confusion, but I know I've seen the terminology where someone takes a BESS, the BESS unit and categorizes it as being 4-hour or 8-hour. Do you have just a very quick and dirty definition of what that means? If that's some,
Sure.
well, I won't speak for you, but just something that we can just point to say, well, what is actually being meant by that 4-hour, indication?
Yeah, certainly. It's actually fairly straightforward, but has unfortunately shown up in the language about BESS. A battery energy storage system has a number of parameters, but the two relevant here are a power rating, how fast power can flow into or out of the battery system, and then an energy rating, which is essentially the amount of power that can be stored at maximum in the battery. And the ratio of those two is the duration or hours that it can supply. So 100 kilowatt hour energy rating and a 25 kilowatt hour rating would be a 4-hour duration battery, because it could be discharged at full power or up to 4 hours, starting from full, and then that would empty it. So that's what the duration refers to.
Okay. And is that a common occurrence where a battery is just drained from, say, full charge to zero charge in one occurrence?
Battery operators would typically moderate that a bit, because there are effects on the battery's long-term viability of discharging at full rate in the extremes of being full or nearly empty. That said, the economics of battery operations would dictate that often there would be a period of discharge that would broadly go from full to empty, because there would be periods of high prices of several hours duration.
Okay. And just, I don't know if you can answer this one more technical question. Can a BESS be discharging and charging at the same time?
No, it cannot.
Okay, that's that's good information for me. Okay, great. All right, thanks. I appreciate just getting that further defined. If it wasn't already in the record, I didn't see it. So, okay, great. So, and the witness is available for a redirect.
Thank you, Your Honor. Mr. Jester, just a couple questions on redirect. You were just asked some specific questions about your experience with battery energy storage systems. Could you give a very brief overview of other experience with BESS that wasn't covered in that response?
Well, first, I want to identify that pump storage is not BESS, but is a storage system of similar characteristics, and I've done a good deal of work on the Ludington pump storage plant, which is located on Lake Michigan in the state of Michigan, and owned and operated jointly by DTE and Consumers Energy. In addition, I have done work on a roadmap on energy storage for the Michigan Department of Environment, Great Lakes and Energy. Have addressed storage modeling in an engagement for General Motors, looking at the potential repurposing of old used automobile batteries as grid storage systems. Have included battery energy storage systems in a model that we developed for evaluation of the Obama era Clean Power Plan. Created a tool for states to evaluate how they would implement that, and included battery energy storage systems in that analysis. And I've advised a municipal utility in Michigan on their integrated resource plan, and that included modeling the potential role of battery energy storage systems in their resource portfolio.
Thank you. I'd like to ask just a couple questions about cross-examination. You were asked regarding witness Arendt's rebuttal testimony.
Yes.
If we could potentially pull up page 16.
Okay, it's off the record. This might take a second here. Level 16. Okay, I think we're there. Let's get back on.
Mr. Jester, on page 16 of Mr. Arendt's rebuttal testimony, he quotes NERC saying, "Natural gas-fired generators are a vital grid resource," end quote. In your opinion, do you think NERC was implying that only natural gas generators are vital grid resources?
No, that quote is from their 2024 reliability assessment, and it is a statement of fact about the current grid. There are 171 references in that document, or uses of the word gas. Last week, I went through and looked at all of those, and most of them are simply narratives about how much gas is used and planned in various regions in North America. The substantive recommendations in the report are about the fact that because of this dependence on gas, there are vulnerabilities in the bulk power system that need to be addressed. And they make recommendations around things like coordination between the gas and electric systems, winterization of gas plants, and the like. Nothing in the report says that gas is the only available resource for providing adequate resources to meet peak energy or non-peak energy demands.
Thank you. Do you recall being asked questions about energy efficiency?
I do.
In cross-examination?
Mm-hmm.
Do you recall being asked whether customers must take action in order to participate in energy efficiency programs?
I do.
And do you have any reason to believe that this requirement would prevent WEPCO from achieving additional energy efficiency savings in its territory?
I do not think that there's any problem in planning for and achieving significantly higher levels of energy efficiency. 4 years ago, in relation to work on a Dominion, Virginia integrated resource plan, I looked at the reports of all investor-owned utilities in the United States in FERC form, EIA Form 861, where annually they report their energy efficiency program costs and results. And there are many utilities that achieve in excess of 2% annual energy savings. And furthermore, there's no increase in cost per unit of savings. For those utilities versus those who achieve lower levels of performance. So I have been involved in regulatory reviews of energy efficiency plans of the Michigan utilities multiple times. All of them perform as planned and at higher levels than is typically accomplished by focus on energy. It's just a matter of intent and spending.
Thank you. I believe at the beginning of WEPCO's cross-examination, you were asked about the ability of alternatives to the Oak Creek plant to meet the stated customer demand. Do you remember that?
Yes, I think so.
Did the modeling conducted by Clean Wisconsin Witness Hoteling present alternative portfolios to the one proposed by WEPCO, including one that accounts for 50% of the new large load customers' load that are cost effective and included less fossil fuel generation resources?
Objection, Your Honor. This is outside the scope of the cross. I didn't ask him about Hoteling's testimony.
Okay, yeah, I'm getting a response from Clean Wisconsin.
I'll withdraw.
Okay.
Last question, Mr. Jester. Given everything you've read in applicants' sur rebuttal and heard from witnesses, including applicants, so far on the stand during this hearing, have your recommendations to the commission regarding WEPCO's application in this docket changed?
No. Excuse me, no.
Thank you. No further questions, Your Honor.
Okay, thanks. All right, great. Thank you. You're excused. And let's go off the record. Before you leave, I'm jealous of your background because I wish I was there. Just like to remind you though, if you appear next time, to have your background turned off. So I don't start dreaming about wherever that.
My apologies.
Okay,
that background obviously is not at this time of year.
Right. Okay, great. So let's see. Why don't we do a 10-minute break? Get back at 10:25. We'll take let me just review. So are we going to be taking Dr. Keim, or is Dr. Keim going to appear or just verify testimony?
If we could, Your Honor, just have Dr. Keim verify his testimony, that will simplify things for Cub.
Sure, that's fine. We'll just take Cub next. All right. So be back in 12 minutes. Thanks.
Thank you, Your Honor.
Okay. Everybody's here. You can start
Can't
with.
see you.
Can't see me. Oh, didn't push the button. There we go. Great. All right. So we can get started with Cub. Who are we taking first?
Thank you, Your Honor. Cub calls Dr. Keim to the stand.
And Steve, you're probably not showing up.
I can't get my camera to come on.
There we go. I turned it off because it was on during the break. So I be able to get an invite to do that now.
Okay. I'm hitting the start video and it's not coming on. Oh, hold on just a second, please. Sorry, let's try this. Your Honor, I keep getting a message that this cannot start your video because the host has stopped it.
Okay.
Okay, now let's see.
There we
you
go.
go. Okay. Thank you.
All right. Okay, let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. And Corey, your camera's off now.
I'm experiencing the same notice, Your Honor.
Huh. Oh, that's what I did. I pushed the wrong button. Okay. Keep doing that now. All right, there we go. Okay, go ahead.
Thank you. Good morning, Dr. Keim.
Good morning.
Did you prepare and cause to be filed direct testimony in this proceeding?
I did.
Okay. And is the information in your testimony true and correct to the best of your knowledge?
Yes.
And if asked the same questions set forth in your testimony here today under oath, would your answers be the same?
Yes.
Do you have any corrections to make to your testimony?
I do not.
Witnesses available for cross?
All right. Do we have any questions at this point?
No, not from the applicant.
All right. Anyone else? No? All right. Thanks. You're excused.
Thank you, Your Honor.
Take care.
All right, Your Honor. We'll do, Dr. Keim and I will do our little awkward role swap here.
All right. Sounds good. So I'll swear witness Singletary in. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do.
Go ahead.
Good morning, Mr. Singletary again.
Good morning.
Please state your name for the record.
Corey Singletary.
And did you file in this proceeding direct, rebuttal, and surrebuttal testimony?
I did.
And did you have errata for your direct testimony?
I did.
And also, did you file 2 exhibits?
I did.
And if I asked you those questions contained in your testimony today or the information in your exhibits, would everything be the same as filed in this proceeding?
It would.
Thank you. The witness is available for cross-examination.
All right. Do we have questions?
Yes, Your Honor. On behalf of the applicant, good morning, Mr. Singletary. This is Joe Wilson.
So let's go off the record for a sec. Can you guys do a chair swap because your camera's on, or just switch your camera? I think that's probably all you need to do.
Very easy to switch chairs.
I think we have to switch chairs, Your Honor.
Okay, that works. So is it Attorney Wilson?
Yep.
Recognize that voice? All right, great.
All right, are we back on?
Yes, go ahead.
Thank you. Mr. Singletary, were you involved in Cub's decision to retain Mr. Burgess for this case?
I was.
Do you stand behind the opinions he's offered in his testimony?
I believe Mr. Burgess's testimony speaks for itself.
You've read it, haven't you?
Yes, I have.
And do you agree with the opinions that he's expressed in that testimony?
Is there something in particular, or are you asking me whether or not I agree with every word he set forth in his testimony to date?
Do you agree with every word he set forth in his testimony to date?
I relied on Mr. Burgess's technical analysis of the applicant's application in this proceeding.
Okay. Let's look at your surrebuttal testimony at page 4.
A second here to adjust. Or more than a second. Okay, I think we're in the right place.
They are at lines 8 through 10. You talk about Mr. Burgess's identification of what he believes to be constraints on solar that in the applicant's Plexus modeling, right?
You'll give me a minute. I need to refresh my memory on that reference.
Just a point of clarification, Mr. Wilson, is
I'm sorry. Who's speaking? Oh, sorry.
this
Go
is
ahead.
Steve? Okay, is Plexus referenced here, or is that just implicit in this analysis?
Well, we'll let Mr. Singletary answer that. I think it's implicit.
Okay, thank you.
In the question.
I'm sorry, I had the wrong testimony up in front of me. Sorry. Yes.
And specifically there, you're referring to Mr. Burgess's critique of the modeling that the company did in response to data request DG 6.9, which was discussed at pages 9 and 10 of Mr. Burgess's rebuttal, right? And we can look at that, Mr.
Yes.
Burgess. That's helpful.
Yes.
Okay. Did you listen to Mr. Burgess's cross-examination yesterday?
I did.
And during that cross-examination, he expanded on his opinion that the inputs for the Plexus modeling runs completed in response to staff data request DG 6.9 may have been manipulated to skew the results and disfavor solar resources, correct?
I would agree that those were the words used, but as a point of clarification, I'm not certain if what exactly Mr. Burgess meant and when he agreed to or used the word manipulated, because that could potentially be used to imply some sort of malicious intent. And I can't speak for Mr. Burgess, but I don't believe that that was his intent.
What's that belief based on?
Well, Mr. Burgess, in his testimony, if I'm recalling correctly, yesterday had also discussed the fact that there are a number of inputs into the Plexus modeling that, depending on what assumptions are made, could produce constraints and lead to particular results, and they could be driven by a number of things. And so I think to use the word manipulated, unless we're very clear on what we mean by that, could be inviting, some implicit meaning that may not exist.
So Mr. Burgess used the word manipulated during his testimony yesterday, didn't he?
Mr.
Objection,
Burgess,
Your Honor. This is beyond the scope of cross. I'm sorry to object on behalf of CUB, but they don't have an attorney, and we keep really getting the same issue with witness.
With witness.
It's not part of cross.
Mr. Hellish, I couldn't hear with witness.
Burgess?
And then you said a few words after that, something about cross. My
Yeah,
apologies.
I said this was beyond the scope of cross, and
Thank you.
we're just relitigating an old issue with yesterday's cross.
Okay.
May I respond?
Yeah.
I don't understand how it can be beyond the scope of cross if I'm doing cross. And I'm trying to understand whether Mr. Singletary agrees with Mr. Burgess's opinions.
Okay. So what I'm hearing is that Mr. Singletary is willing to provide an answer, but is not willing to speak for the intent of witness Burgess. Is that a roadblock to getting an answer and moving on, or?
Well, I don't think it is, except that I would note that he did just say he didn't think that Mr. Burgess intended a particular meaning by saying manipulate. But I can ask my next question.
We can just say there's no basis for the witness to know the intent of another person. And I don't know. I guess it's just not relevant. So let's move on.
I think the question I had asked and hadn't gotten an answer to, and I'm not clear what the status of the objection is, was did Mr. Burgess use the word manipulated yesterday?
Should I answer the question, Your Honor?
Yeah.
Okay. My recollection, and ultimately the transcript, the commission will be able to read the transcript for itself, but my recollection was the first time the word manipulated entered into that cross-examination was from Attorney Goldschmidt. And so he was responding to Attorney Goldschmidt's use of that term. And to my recollection, there was no discussion about what was meant by that. And to my earlier point, the term manipulated within simple modeling analysis could have a innocent colloquial usage, or it could be used to imply other meanings.
That's not responsive to the question I asked. Did Mr. Burgess use the term manipulated during his testimony yesterday?
Yes.
Your Honor, can we pull up Mr. Burgess's rebuttal, please? And particularly at page 8, lines 1 through 3. There, Mr. Singletary, Mr. Burgess says that he has, quote, serious concerns about that particular model run's assumptions for solar resource additions, which I believe have skewed the results to select more OCCT units, correct?
Yes.
So taking that testimony and Mr. Burgess's statements on the stand together, would you agree that in this case, Mr. Burgess has offered his opinion that the inputs to one of Wisconsin Electric's modeling runs may have been manipulated to skew the results and disfavor solar resources?
Since you're asking me that question, I would not use the word manipulated. Mr. Burgess's testimony speaks for itself.
I'm asking you what you believe Mr. Burgess has testified to in this case, not asking for your opinion of it.
Can I have the question read back, please?
Yeah, let's read it back.
The very last one or before that?
The question from Mr. Wilson.
Well, the very last question was, I'm asking you what you believe Mr. Burgess testified to in this case.
Yeah, so
Yeah, okay. So taking that testimony and Mr. Burgess's statements on the stand together, would you agree that he, in this case, Mr. Burgess, has offered his opinion that the inputs for one of Wisconsin Electric's modeling runs may have been manipulated, skew the results, and disfavored to the resources?
Could I have a clarification from you, Attorney Wilson, by what you mean by manipulated?
I mean, whatever Mr. Burgess meant when he was using the term yesterday.
Okay, I'm asking because you're asking me about the testimony of another witness, and that potentially bears on their understanding and the attorney's understanding in that cross-examination of a particular word. And I just want to make certain, for the purposes of our conversation here, we are on the same page with respect to meaning.
Okay. If we agree that by manipulated here, what is meant is Wisconsin Electric selected particular inputs for Plexos to skew the results of the analysis to disfavor solar resources and favor the OCCT project. With that understanding of the word manipulated, do you believe that Mr. Burgess has offered his opinion that the inputs for one of Wisconsin Electric's modeling runs may have been manipulated to skew the results and disfavor solar resources?
No.
So you don't think he's testified to that?
No, with the definition that you just gave, my understanding of Mr. Burgess's testimony is that inputs to the applicant's Plexos modeling, and there are a lot of inputs to that modeling, and the inputs that the company chose for the variety of reasons the company chose them, produced what he believed were skewed results, but I don't believe he spoke to intent. Right? You can have inputs to a model that are chosen genuinely and honestly on the part of the modeler without any sort of nefarious motive that quantitatively skew a result.
You yourself subscribe to Mr. Burgess's theory that Wisconsin Electric selected Plexus inputs that disfavor solar resources and select more OCCT units?
I guess there's a couple of parts to that, and to answer your question, because I believe we're talking about this specific issue about these model runs, right? 6.3 and in particular 6.9, what we're referring to run 6.9. And I would agree with Mr. Burgess that a review of the results certainly seems counterintuitive, and when considering the other model results from the same run series. Now, looking to the rest of your question, I believe there was some testimony yesterday, and there's also testimony in this proceeding about the various parameters and considerations that WEPCO applied when developing its modeling, including some degree of preference for locally sited resources, some evaluation, although not quantitative, with respect to the risks associated with certain types of resources like IPPs and such. And all of those things go into the input selection for the model. And so the formulation of all of those inputs together could produce a situation where the results are skewed one way or another, and in this case could be skewed in a way that would not select as much solar or renewable resources.
What specific input or inputs do you understand Mr. Burgess to have been referring to, and he's talking about selecting inputs to skew the results?
So I believe Mr. Burgess testified yesterday, and this is consistent with my general understanding of his testimony, is that upon review of these model results, he observed a result that seemed unusual from his perspective. That would be the results of run 6.9. And I believe as he testified yesterday, he was unable to review the inputs for the Plexos inputs for that set of model runs. And so that's where we end up in this situation where, you know, he has put some of his opinions into the record with respect to what could have produced those results, but that was within the context of not being able to review the inputs.
Have you reviewed the company's Plexus modeling inputs for the runs performed in response to data request DG 6.9?
I have not.
As you sit here today, can you say one way or the other whether the company manipulated Plexus modeling inputs for the runs performed in response to DG 6.9 to disfavor solar resources and favor the OCCT units?
I would return to what I had responded earlier, that there are a number of inputs and assumptions that the company used, some of which I've already mentioned, that could result in selecting less solar. If you're asking me if the company set out with an ex-ante goal to have the model produce less, to select less solar, then no.
So you do not believe that the company purposely selected particular modeling inputs to disfavor solar resources and favor the OCCT units in model run 6.9, correct?
I would, you know, stand by my previous answer and I guess add the clarification that there's a distinction between the modeling inputs being selected specifically with the goal of not selecting or reducing the amount of solar that is selected within the model, and having model inputs that may produce a result that does not select solar. Does that make sense, Attorney Wilson?
It makes sense, but I don't think you answered my question, which is, could you verify that your testimony is not that the company specifically and purposely selected modeling inputs for the runs completed in response to data request DG 6.9 to disfavor solar and favor the OCCT units?
I have no evidence to suggest that the company decided ex ante in preparing these model runs to prepare the model in such a way as to not select solar.
Have you read Dr. Grant's surrebuttal testimony on behalf of commission staff?
I have, but you'll probably have to point me to specific places. I don't remember all of it off the top.
Your Honor, can we take a look at pages 3 to 4 of Dr. Grant's surrebuttal?
Okay, let's go out the record for a sec. And you said page 4?
3 to 4, yeah.
All right, I think we're there. Let's get back on the record.
Here at pages 3 to 4 of his surrebuttal, Dr. Grant describes how staff specifically looked into Mr. Burgess's suspicions about Plexos modeling inputs, right?
Yes.
And Dr. Grant testified that staff, quote, did not find any evidence that the Plexos inputs had been altered by the applicant to change the ability of solar resources to be chosen by the model in years 2027 to 2029 compared to other runs, end quote. Correct?
Yes.
Does Dr. Grant's testimony on this point alleviate your concern about selection of modeling inputs to favor one resource over another?
Again, I believe Mr. Burgess spoke to this yesterday, but since you're asking me about Dr. Grant's testimony, the way I read his testimony, and perhaps Dr. Grant can clarify later today, is that his review did not find any evidence that the Plexos inputs had been altered by the applicants to change the ability of solar resources to be chosen by the model in the years specified here as it relates to the prior model runs or the original Plexos modeling done for the GRP. And so that doesn't speak to whether or not there are underlying inputs in the Plexos modeling that would produce the result that we're talking about. My understanding of what Dr. Grant said here is that when he looked at the Plexos inputs and compared them to the prior Plexos inputs that staff had reviewed, that there wasn't, that's basically what he's testifying here, that there weren't such changes here. But it doesn't, my understanding is it doesn't speak to all of the Plexos inputs, but rather whether there was a change to earlier and later.
Has Dr. Grant expressed any concern that any of the company's modeling inputs, either before or after the model runs completed in response to DG 6.9, were somehow manipulated or improper to favor one resource over another?
Hang on. You can ask Dr. Grant that question, but it's not appropriate for this witness.
I want to talk about integrated resource plans, Mr. Singletary. You discussed the role of integrated resource plans, or IRPs, in utility planning throughout your testimony, right?
That would be fair, yes.
And is it fair to say that you believe IRPs should have an expanded role in utility planning in Wisconsin?
In my testimony, I make a distinction between the sort of quantitative element of an integrated resource plan and the regulatory review. Which are you referring to?
Well, it's your view that there should be expanded role for IRPs in both quantitative evaluations of projects and regulatory reviews of utility plans more generally, right?
Yes, with the understanding that if maybe taking it in order on the quantitative end, the WEC Energy Group utilities are conducting their resource planning under the GRP, which is an IRP analysis. Alliant Energy has conducted and conducts IRP analyses. Excel Energy's affiliate, Northern States Power Company's resource planning is already done under an IRP that is reviewed by the Minnesota Commission. So with respect to those utilities, it appears to me that many of our utilities have sort of embraced that type of approach as a best practice, or I hope it's been embraced as a best practice going forward. To the second point, my testimony is that I believe that given that positive move on the modeling and quantitative and resource planning or modeling front, that I believe it is appropriate for the review of utility resource planning to be conducted in a way to allow the commission to evaluate the reasonableness of the entire portfolio as a whole, rather than facility by facility.
In your sir rebuttal testimony, you make clear that CUB is not advocating that an IRP be completed before a decision is issued in this case, right?
Again, to clarify, CUB's position in this particular proceeding is not that we pause everything and conduct a standalone integrated resource plan analysis or evaluation or review prior to making a decision on the OCCT case. There is an IRP, it's the GRP. So again, I just want to make that distinction.
Yep. Is it your testimony that the commission should include an order point in its order in this case that would require the broader type of IRPs you've been discussing going forward?
I would agree with that, yes.
Is it your position that the commission should condition approval of the OCCT project on having Wisconsin Electric participate in this broader sort of IRP going forward?
I would like that, yes.
Would you advocate having that broader IRP encompass other generation projects that are already pending in open commission dockets?
Can we just clarify, are you speaking to WEPCO only, joint WEPCO and affiliate cases? I mean, I don't know how many cases there are out there pending at this point. And then we're talking about buy-sell or just CPCN, CA?
Let's break it down. Good question, Your Honor. Mr. Singletary, would you advocate having the broader sort of IRP process that you've described apply to currently pending construction dockets, i.e. CPCN or CA dockets for Wisconsin Electric Power Company and Wisconsin Public Service Corporation?
Maybe to simplify, maybe getting you the information that you're looking for, Attorney Wilson, the reason that the recommendation or the position from CUB in this proceeding sorry, let me try this again. The reason that the position of CUB here is that any type of sort of holistic IRP analysis is an in the future consideration is in recognition of the statutory timing constraints that the commission has currently in this proceeding and a few others. You know, there's a practical reality here where the commission has a deadline and has to act. And so to conduct that type of separate review would be challenging to do given those constraints. Now, I don't know off the top of my head where all of the other pending dockets are insofar as completeness determinations, schedules, and that type of thing. There may be other CA or CPCNs or maybe even acquisition proceedings for resource acquisition that the timing could allow for that, but I would hesitate to say definitively yes or no to everything that is currently pending or may be coming before the commission.
So is it fair to summarize your position that it ought to be a case-by-case evaluation of that question?
If the commission were to agree with our recommendation that on a going forward basis, resource plans should be evaluated on their own, separate from specific facilities, then the commission would be able to decide what, if any, pending applications it could roll up into that. That's something the commission would have to decide.
Would you agree that Wisconsin Electric Power Company is much further along in terms of presenting integrated resource plans than it was earlier in the GRP process?
When you mean further along, can you clarify that for me?
Sure. Is the company presenting more sophisticated and useful integrated resource plans than it did earlier in the GRP process?
As compared to the first slate of resources brought before the commission under the GRP, I would agree, yes.
And among that first slate of resources were projects like the Paris Solar Project, Badger Hollow Solar Project, and the Weston Rice Project, right?
Subject to check, that sounds right.
You criticize the structure under current Wisconsin law, which requires consideration of individual projects one by one, as distinguished from the broad IRP that you would prefer, right?
I'm sorry, that you would prefer?
Yeah, correct.
Thank you.
Yes, and I guess to clarify, my critique is the way that facilities are brought forth and reviewed before the commission under what I'm only assuming is an interpretation of current statute with respect to the way that individual CPCN and CA applications have to be reviewed.
You would agree, correct, that Wisconsin law doesn't currently require comprehensive resource planning in the way that you've been suggesting it should, right?
It neither requires nor precludes. Correct.
The GRP that has been discussed extensively in this case covers more resources than just the OCCT project, correct?
Correct.
Is it your understanding that the GRP rests on economic modeling that allows the model to pick various resources based on assumptions about the future?
In general terms, yes.
And is it your understanding that the GRP includes multiple scenarios and sensitivities concerning the future that alter the input assumptions?
Yes.
You've had access to WEC Energy Group's GRP in this case, correct?
Yes.
You've had the opportunity to ask questions about it in discovery, correct?
Yes.
Would you agree that? Can we just clarify though on that point? Did Cub have access to the Plexos program and be able to run its own model runs?
Cub does not have access to Plexos.
Okay, I just want to make sure I knew that. Okay, go ahead, sorry.
Would you agree that facts or circumstances might change in ways that could render decisions reached in a broad IRP process outdated?
I'm sorry, did you say outdated?
Outdated.
Okay, thank you. Yes, but that certainly doesn't seem to get in the way of all of the other states in the country that have integrated resource planning requirements.
You're advocating an IRP be conducted every 2 to 3 years, right?
That was an example interval that I provided in my testimony. Yes.
And do you think that's the right interval for Wisconsin?
It's a little bit of a subjective policy call, but if you would like, I can elaborate. I mean, I believe that somewhere in that range, yes. Anything shorter than 2 would, I think, wouldn't be practical. Anything longer than or much longer than 3, you potentially lose some of the value. Gets to your issue about circumstances changing. So based off of my understanding of integrated resource planning requirements in other states, 2 to 3 years seems a pretty common interval.
How long would the broad IRP process that you're envisioning take to complete from initial development of the plan through to a commission decision?
So, I'd just like to interrupt for a second. So my understanding is that Cub is saying that an order in this case wouldn't be contingent upon ordering WEPCO to go under an IRP, but that an order condition to do IRPs in the future is a recommendation of Cub. Is that right? Okay. All right, go ahead with the questions. Thanks.
I didn't hear an answer to when you said, is that right?
Oh, yeah, go ahead, Corey, and just answer that.
Yes, that is correct.
Thank you.
Sorry. So we want to read that back. Wilson's last question.
Question, how long would the broad IRP process that you're envisioning take to complete from initial development of the plan through to a commission decision?
I don't know if I can speak to the utilities part of that prior to the filing of an IRP, but from some examples that I'm aware of, understanding that while it wouldn't necessarily be the case, but there may be some initial teething challenges the first time we do anything in the regulatory space. A year in terms of review and final commission approval. And the most recent example I have of that is the Minnesota Excel Integrated Resource Plan, which was filed, I believe, February-ish of last year. And that commission had a decision, although there's no final order to my knowledge today, near the end of February of this year. So that's about a year.
Okay. Would you agree that if the legislature wanted the commission to conduct formal IRPs, it could pass legislation requiring the commission to do that?
Yes.
Are you aware that a form of IRP legislation was included in each of the last 3 budgets that Governor Evers proposed, including his most recent budget proposal released on February 18 of this year?
I have not reviewed Governor Evers' most recent budget proposal, but I'm willing to accept your statement.
None of those 3 proposals have made it through the legislature, have they?
No, but I would answer the same way I did in the Paris Rice proceeding, in that as a matter of course in Wisconsin, when things that are more of a policy nature find their way in budget proposals, they tend to be stripped out.
Have any of those proposals even made it to a legislative hearing, to your knowledge?
I don't have knowledge of that. I don't believe so.
Would you agree that it's clear at this point the Wisconsin legislature has no desire to enact IRP legislation, at least based on recent actions?
Your Honor, I don't know if he can testify to legislative desire.
Oh, an objection. Do we have a response?
Well, I'm just asking how he interprets the legislature's response to IRP legislation being included in budgets the last 3 times and nothing happening.
Why don't we ask, what's the likelihood of an IRP proposal passing the legislature in this session?
Sure. Are you wanting me to ask that question?
No,
Judge Newmark, I thought you were posing it.
Yes, yeah. The witness can answer to the extent he knows.
Yeah, if you'll just give me a minute, that's an interesting question. I don't know if I've contemplated that.
Okay,
I have
well,
no knowledge that would give me insights one way or another into the likelihood of the passage of such a bill in the current session or environment in Wisconsin.
Okay, let's answer the question. Let's move
on. Mr. Singletary, you have undergraduate degrees in biology and international studies, right?
Correct.
And you have a master's in international public affairs?
Yes, undergraduate certificate in energy policy analysis.
And you have a lengthy history of working at the Public Service Commission of Wisconsin before joining CUB, correct?
Yes.
Have you ever yourself negotiated an EPC or engineering procurement and construction agreement for a power plant?
No.
Have you ever negotiated an EPC agreement for anything?
No.
Did any of the training or classes you took in college or graduate school or in connection with your energy policy certificate involve negotiation of EPC agreements?
I have no formal training in contract negotiation. No.
Do you claim to know what standard terms are typically contained in EPC agreements?
I believe as I testified in a general sense, I have a typical understanding of what types of provisions typically show up in an EPC, but if you're talking about the very specific terms under any one of those categories, then no.
Yeah. Would that lack of specific knowledge about terms of EPC agreements extend to specific terms of force majeure clauses?
Are we speaking about the utility industry specifically or the universe of force majeure clauses?
Let's focus on the utility industry.
Could I have Mr. Wilson's question read back for me, please?
Yes, read that back.
Question: would that lack of specific knowledge about terms of EPC agreements extend to specific terms of force majeure clauses? Answer: are we speaking with utility industry specific about the utility? Oh my gosh. Are we speaking with the utility industry specifically or the universe of force majeure clauses? Question: let's focus on the utility industry.
Beyond the EPC agreements that I have reviewed in the course of my work, I would agree with your initial question.
Could we please take a look at pages 16 to 17 of the rebuttal testimony we've got up? And on these pages, starting at line 11, page 16, you're discussing force majeure provisions generally, correct?
Yes.
You make clear that you are not asking the commission to order the company to rewrite the force majeure provision contained in the EPC contract between Wisconsin Electric and its contractor for this project, Burns and McDonnell, correct?
Yes.
I want to make sure that I understand what you are suggesting. Is it correct that you want the commission to come up with its own force majeure terms that define force majeure more restrictively than the EPC contract's force majeure provision?
I guess as an initial matter, my recommendation is that the commission, if it were to authorize the project in whole or in part, set forth its conditions or thinking or parameters on how it would evaluate instances of force majeure in future proceedings, particularly with respect to cost containment and cost overruns. The specific recommendations I have set forth in my testimony, I would agree would likely be read as more restrictive than what is set forth in the existing EPC with Burns and McDonnell.
And you're asking the commission to impose your force majeure terms on Wisconsin Electric in its final order, right?
Certainly that would be preferred, but since this is, to my knowledge, the first time we've really approached this issue in a construction proceeding in this way, the commission could view my recommendation as suggestions, and it can arrive at its own conclusions as to what is appropriate in this proceeding.
Your proposal is that to the extent there's a cost overrun that is the result of something that you don't believe is force majeure, those costs should not be recoverable from customers, right?
That's not precisely correct. What would happen is that would not, or sorry, maybe backing up. The items that I identify, if something were to fall into one of those categories, it would not then be classified as a force majeure event or instance. And so in the commission's review of that issue, let's say it's cost overruns, that it would not be viewed as force majeure. That is not to say that the utility couldn't make other arguments as to reasonableness, but that we would sort of we would remove that force majeure element, which based off of some past cases tends to complicate the review of cost overruns specifically.
You didn't make any attempt to suggest force majeure terms that would be consistent with force majeure terms that are standard in EPC agreements, did you?
No.
I want to talk just a little bit about reliability. I know you know what NERC is, the North American Electric Reliability Corporation. Do you consider NERC to be a credible source on the issue of grid reliability?
They are one such source, yes.
Do you consider them to be a reliable source?
Yes.
I know you know what reliability first is as well. Do you consider reliability first to be a credible source on issues of grid reliability?
In the same way as NERC overall, yes.
Do you consider MISO to be a credible source on issues of grid reliability?
Yes.
In the Paris Rice case, we spent some time looking at Mr. Arndt's testimony. We can do that again, but I have a fairly broad question that may not require it. Do you have any basis to dispute Mr. Arndt's description of NERC's and Reliability First's concerns about reliability in MISO?
No.
And do you have any basis to dispute NERC's view as described by Mr. Arndt at page 15 of his rebuttal testimony that MISO is at quote unquote high risk of experiencing electricity shortfalls beginning this summer?
With the understanding that there are always nuances, because this is a sort of binary statement, that there are nuances underneath that, I have no reason to dispute that statement.
Does CUB oppose approval of the OCCT project?
As applied for, yes.
Nothing further.
Excuse me, thanks. All right, any other cross for this witness? Nobody? Redirect?
Yes, I hope just one question, Your Honor.
All right.
Mr. Singletary, Mr. Wilson asked you several questions about manipulation to produce a skewed result. And you said one thing that you could take all of the assumptions that go into a GRP and you might not have any ill intent ex ante, but still end up with a skewed result. Could you explain that a little bit further?
I'll take, for example, as just a simplest example, perhaps, is there's been some testimony, and I believe it included yesterday, one of the considerations the company used in developing the GRP and its model inputs related to a degree of preference for resources sited within Wisconsin, perhaps even specifically to WEPCO's zone within MISO. And while there can be a lot of really good technical reasons for that one way or another, having that be part of the consideration and input formulation could bias the results away from resources in other parts of MISO that could be acquired on a lower levelized cost basis as enabled by interstate transmission infrastructure, as an example.
I have nothing further, Your Honor.
Your Honor, I have one question of recross.
All right, go ahead.
Mr. Singletary, as you sit here today, do you yourself harbor any suspicions that Wisconsin Electric manipulated Plexos modeling inputs with ill intent to favor the OCCT units and disfavor solar resources?
That's been asked and answered.
It hasn't.
No, we've gone over this so many times. I'm not going to allow another question on it. You're excused. Thanks.
Thank you.
Okay, so we have Cub done.
Yes, Your Honor, that's all of our witnesses.
Okay, let's move on to our next. It's now been here about an hour. So clean. Who are we calling first? So do we have a witness that no, I think we're good.
No, not today. We're good. Yeah.
Who do we have for clean?
Thank you. Clean Wisconsin will call witness Chelsea Hoteling.
Let me just adjust my screen here. Let's go off the record and do this. It's like we have Attorney Proctor Brown up for questions. I'm going to change your name now.
Thank you.
Get that right. All right. Great. Okay, so all set. Let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Good afternoon, I believe where you are, Ms. Fatailing.
Yes,
Could you
good afternoon.
please state your name for the record?
My name is Chelsea Hotailing.
The last name, please.
Hotailing.
Thank you, Ms. O'Tailing. Are you the same Chelsea O'Tailing that prepared and caused to be filed direct and surrebuttal testimony and 19 associated exhibits in this docket?
Yes, I am.
To the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes, they are.
Do you have any corrections to your testimony that you'd like to provide today?
I do not.
Thank you, Ms. O'Tailing. Your Honor, the witness is available for cross.
Okay, we have questions from the applicant.
Yes, Your Honor. Thank you.
Go ahead.
Good morning, Ms. O'Tailing. I believe we met during the Paris Rice hearing about a month ago. Do you remember that testimony?
Yes.
I'm going to ask you some really almost verbatim questions from that proceeding. So hopefully you can bear with me.
I wasn't crossed in Paris. I was sworn in, but I wasn't crossed.
Oh, my apologies. I misremembered. But
Okay.
I do have some
I misunderstood
questions.
your question. I thought you meant like we saw each other on the Zoom, but no, I wasn't crossed in Paris.
Okay, my apologies. So I want to ask you some questions that I've asked other witnesses. If you just bear with me on these. And Your Honor, I'm going to bring up Mr. Arndt's rebuttal at page 13. They already have suspected that.
A lot of documents here. Hang on. Just have to go to the source.
Ms. O'Tailing, did you, and before we bring it up, did you read Mr. Arndt's rebuttal testimony in this case?
Yes, it's been a while, but I read it.
Oh, rebuttal, Your Honor. I apologize.
Oh, no. It goes right to this page now. It's just automatic.
So Ms. O'Tailing, we have page 13, I believe, of Mr. Arndt's rebuttal testimony up in front of you.
It's 15 that I have here.
Okay, if you could go to 13, that'd be great, Your Honor.
Sure.
So Ms. O'Tailing, we now have page 13 of Mr. Arndt's rebuttal testimony in front of you. Fair to say that beginning on page 13 and then through about page 17, Mr. Arndt is discussing reliability concerns expressed by the North American Electric Reliability Corporation, NERC, Reliability First, and MISO. Would you agree with that?
Yes.
What is NERC to your understanding?
The North American Electric Reliability Corporation, and they're tasked with doing studies and proposing regulations around the reliability of the bulk power system.
And bulk power system is sometimes abbreviated BPS, right?
Yes.
And the grid could be a synonym for the bulk power system. Do you agree with that?
Yes, I do.
And kind of more specifically or tangentially to your definition, NERC is a not-for-profit international regulatory authority whose mission is to assure the effective and efficient reduction of risks for the
I'm sorry,
reliability.
it's to assure the
Effective and efficient reduction of risks to the reliability and security of the grid, right?
Yes.
NERC is a credible source on the issue of grid reliability, right?
Yes.
What is reliability first, to your understanding?
At a high level, my understanding is that someone of a branch serving facilities similar to NERC, assessing reliability in particular regions, and that they were sanctioned by FERC, the Federal Energy Regulation Commission.
So would you agree that Reliability First is the regional organization for the reliability and security of the electric grid under delegated authority from NERC, covering Wisconsin?
Yes.
Reliability First is a credible source on issues of grid reliability, right?
Yes.
Do you consider MISO to be a credible source on issues of grid reliability?
Yes.
And you're welcome to review this testimony, but without going into these 5 pages in detail, do you have any basis to dispute Mr. Arndt's description of NERC's and Reliability First's concerns about reliability in MISO?
I don't.
Your Honor, if you could go to page 15.
Okay.
Here on page 15, NERC's conclusion is MISO is at high risk of experiencing electricity supply shortfalls beginning in summer 2025, based on planning resource margins derived from anticipated resources and demand forecasts. Did I read that right?
Yes.
Do you have any basis to dispute NERC's views on the potential of MISO not being able to meet its electric demand?
I wouldn't dispute, but I would clarify that they're making this under the assumption of what they're saying, anticipated resource and demand forecasts, and those are subject to change. So in their perspective, what they were looking at, that's what they deemed, but there's, open to change and those anticipated resources or demand forecasts.
And I think it's at the next page, Your Honor, if you don't mind scrolling. Here, there's a quote, natural gas-fired generators are a vital grid resource. Do you see that?
Yes, I see the quote.
Do you have any basis to dispute NERC's view about the importance of natural gas generators for reliability?
I don't, but I don't know the full context of the sentence in that source. And so there's more information that could be tied to that quote. But as it stands from just what's presented as testimony, that is what is said.
Thanks. And switching gears to energy efficiency and demand response, is it your position that energy efficiency and demand response are potential alternatives to the entire 1,100 megawatts of the OCCT project?
As I clarified in my cerebral testimony, that is not the case. The alternative modeling I performed was looking at a resource portfolio of different resources. And yes, demand response and energy efficiency were part of that, but they weren't replacing the full project.
Thank you. Do you have any understanding about the Wisconsin's statewide focus on energy program?
That is not part of the scope of my testimony. My testimony was only related to how I modeled the demand response and energy efficiency inputs that Witness Sherwood developed and how I modeled those in Plexus and any modeling results related to those resources. But any questions related to energy efficiency demand response beyond that should be directed to Witness Sherwood.
Yeah, so you incorporated energy efficiency and demand response in your modeling, right?
Yes, I took inputs that Witness Sherwood developed based on her own expertise and knowledge, and I took those and I modeled them in the Plexus model.
So I'm not asking you about Ms. Sherwood's testimony. Do you personally have an understanding of Wisconsin's statewide focus on energy program?
That was not part of the scope of my testimony. I was strictly taking the inputs that Witness Sherwood developed and modeling them in Plexus. That was not part of the scope of what I was working on.
Yeah, and respectfully, that's non-responsive to my question. I want to understand your knowledge about Wisconsin's statewide focus on energy program. Do you know what you know about Wisconsin's statewide focus on energy program?
That was not part, that was what Ms. Sherwood worked on as part of her development of the inputs. And so my scope was just working on implementing them in the Plexus model. And so I was not working on the program implementation or the energy efficiency programs. I was strictly working with modeling in Plexus.
Right. And again, this is the third time I'm asking. It's a pretty simple question, right? Do you personally have any understanding about the Wisconsin statewide focus on energy program?
No, because that was not part of the work I was doing in Plexus.
Right. The no is what I needed, and I don't think there's a valid objection there, but just for the record, that's your answer. You do not have an understanding of Wisconsin's statewide focus on energy program, correct?
No, because that was not part of what I was working on in Plexus.
Thank you. Do you have an understanding of energy efficiency programs generally, or did you just accept Ms. Sherwood's testimony at face value?
My expertise is working on implementing.
That's asked and answered. She said she put the results of energy efficiency data into her model. So it's already covered.
Respectfully, Your Honor, it's the same as statewide focus. I just want to see if she has any understanding of energy efficiency programs generally. And if she doesn't, then we can move on.
Yeah,
so,
that question's fine. It's just the rest of it was already answered.
Oh, okay. Thank you. Ms. Sherwood, do you have an understanding of how energy efficiency programs operate generally?
At a high level, but my expertise is in modeling them.
Okay, so you do not understand the details of energy efficiency programs. Is that your testimony?
Not at a high level of how to implement them in the model. Witness Sherwood is the DSM expert.
Okay. Do you understand that energy efficiency programs generally require consumers to take action to be effective?
Yes, that's my understanding, but their action can also be influenced by how the programs are offered and incentives that are offered to customers.
The consumer actions can be influenced, but they can't be mandated. Would you agree with that?
Yes.
And the same is true of demand response programs. You don't have a detailed understanding of how those programs are implemented, but you understand them at a high level. Is that right?
That's correct.
And so the same thing is true of demand response programs. To be effective, they rely on consumers to take action. Those actions can't be mandated. Do you agree with that?
They can't be mandated, but they can be influenced.
Thank you, Ms. Hoteling. That's all the questions I had, Brenner.
Okay. Any other other parties? Okay, how about let me ask the witness one question. Witness Holtling, are you an attorney?
No, I am not.
Okay, and now redirect?
No redirect, Your Honor. Thank you.
Okay, thanks. You're excused.
Thank you.
Just want to go off the record for a second. And maybe it's Attorney Bedford. If you could remind me, does Tyler Tomaszewski have a timing issue? You mentioned that in the morning.
Your Honor, witness Tomaszewski is going to be available after noon
Okay.
today, but then he will be going into a mandatory training at 1. So if there's any way that we could have him verify his testimony sometime during that hour, I think that would be ideal.
So only between, okay, just that hour. So I thought I saw him join us.
Oh, he says he's available now.
And this would be, so let me just ask.
And I don't believe there's any cross-examination for him.
Right. Let's just confirm it. Do we expect any cross for witness Tomaszewski?
Not from applicant.
Are you on or off the record?
Off.
Okay.
Off, yeah. I saw you eating, so I figured you were. I'm sorry, I didn't mean to embarrass. Let's see. So let's call him quick and then we'll move on from there. So let's bring up witness Tomaszewski. You're there.
Hello. Can you see and hear me?
Can't see you yet. Why that's...
I can see me.
Yeah,
Maybe it just takes a moment.
There he is.
Ah, perfect. All right, great. All right. Yeah, just keep that hand up. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Please state your name for the record.
Tyler Tomaszewski.
And what is your position at the Public Service Commission of Wisconsin?
I am currently a program and policy supervisor with the Office of Environmental Analysis.
Did you file or cause to be filed direct testimony in this docket?
I did.
And are the statements and representations in the testimony you filed in this case true and correct?
Yes, with the exception of, I believe, when I filed my testimony, I was an environmental analysis and review specialist, and that was what was specified in my testimony, but I've got another position now.
And other than that, do you have any additions or modifications to your testimony at this time?
No, I do not.
Your Honor, the witness is available for cross-examination.
All right, are there any questions? Just confirm that for the record.
No questions from applicant, Your Honor.
Okay, nobody else? All right, thanks very much. You're excused.
Thank you.
All right, thanks for accommodating commission staff, and we'll move on with the next witness from Clean, Wisconsin.
Clean, Wisconsin calls Mr. Michael Goggin.
Hi there.
Hi, let me find you here. There we go. And let's go off the record for a second. I'm going to change my view. This is just not working right. Okay. I think I'm trying to use some sort of AI thing going on. It's just not working. I think they need more capacity or whatever. I can't explain it. All right. So there's witness Goggin. Raise your right hand. Let's get on the record. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
Yes.
All right. Great. Go ahead.
Thank you, Your Honor. Good afternoon. Where you are, Mr. Goggin, could you please state your name for the record?
Sure, it's Michael Goggin, and that's Goggin.
Mr. Goggin, are you the same Michael Goggin that prepared and caused to be filed direct and sir rebuttal testimony and 27 associated exhibits in this docket?
Yes.
To the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes.
Do you have any corrections to your testimony today?
No.
Thank you. A couple questions responsive to sir rebuttal for the witness. Your Honor, could we pull up witness Gerlikowski's sir rebuttal?
Yes, hang on. Okay.
On page 2. Thank you. Mr. Goggin, on page 2 of his sir rebuttal testimony, WEPCO witness Gerlikowski discussed the active wind resources seeking interconnection in Wisconsin. He states that Wisconsin Electric would need to procure nearly 60% of all wind generation being developed in Wisconsin to replace even one of the 5 units of the OCCT project, end quote. Do you have any response to that testimony?
Yes, a few things. One is that this is talking about the accredited capacity of the wind resources, and their the energy generation is a much higher share of their nameplate capacity. And so because Wisconsin Energy needs both energy and capacity to meet its needs, wind energy makes a much larger contribution on the energy side, as I outlined in my direct testimony. And more generally, I would point out that the interconnection queue is a dynamic list of resources seeking to interconnect, and in response to supply and demand, including the demand from Wisconsin Electric, new generation resources, including wind, would enter the queue and then can proceed towards development. So it's not a static number that is a finite list of projects that are available.
Thank you. That's all for witness Kerlikowski's rebuttal. Next, I'd like to ask a couple questions about witness Arendt's rebuttal.
What page?
Page 2 of this one as well. Thank you. Mr. Goggin, on page 2 of his rebuttal testimony, WEPCO witness Arendt says, quote, says wind, quote, can have limited or no availability in extremely cold weather, even if equipped with cold weather packages, end quote. What is your understanding of the performance of wind resources in extremely cold weather?
All resources are susceptible to outages at extreme temperatures, and we've seen that play out for gas generation in a number of recent events. I'm aware of one event where temperatures reached the extreme cold and were below the minimum operating temperature of some wind plants in MISO. This happened in one of the polar vortex events a few years ago. This is an extremely rare event, would typically happen, maybe once in the lifetime of a wind project. And it also, these extreme weather events of that extreme tend to be relatively geographically isolated phenomena where temperatures would be below that extreme low level in only a relatively small area. And so the geographic diversity of the wind fleet, which exists today because of the large number of wind projects that are spread across MISO, and is only increasing as MISO expands wind energy development across different parts of its footprint, counteracts this concern, because if it's extremely cold in one part of the footprint, other parts of the footprint are generally not below that temperature, and so the wind plants can continue operating in those other parts of the footprint and ensure that the total supply of generation is adequate.
Thank you. And Mr. Goggin, do you have any knowledge about how gas generation fared in that event that you described?
It experienced widespread outages due to both equipment failures, like all generating equipment at cold temperatures, equipment freezes, pipes break, material becomes brittle and breaks. Gas also experienced gas supply constraints due to both the freezing of wells, and that limited the injection of gas supply, as well as pipeline constraints. And we've seen this play out in a number of events across the country and several in MISO across various polar vortex and bomb cyclone related events in the last decade.
Thank you. On a related topic, but not related to witness Arendt's testimony, did you hear the testimony of Cub witness Burgess yesterday about the effects of the testimony he gave on cross-examination about the effects of climate change-driven weather events on wind and renewable energy droughts?
I did.
Do you have any knowledge about what the scientific literature says about that topic?
Yes, I'm not aware of any studies that have shown that climate change will increase the frequency or magnitude of wind or renewable energy droughts in the Midwest region. The climate science around projecting the impacts of climate change on specific wind speeds and wind drought events is highly uncertain. These models are not generally designed for that level of locational granularity and chronological granularity. And I would also point out that wind and solar resources tend to have negative correlations during these drought periods. The type of events that cause wind droughts tend to increase solar production. And so a diverse portfolio of wind and solar counteracts any risks from these drought events. I would also point out that the geographic diversity of the wind fleet and the solar fleet to a lesser extent in MISO also counteracts these unusual events where there are wind droughts.
Thank you. No further questions. The witness is available for cross.
All right, great, thanks. So we'll start with the applicant on cross.
Thank you, Your Honor. If you just give me 30 seconds, I want to pull up Mr. Ernst's rebuttal on my side just so I can.
Sure, let's go off the record.
Thank you. Apologies for that, Your Honor. Thank you.
No worries. All right, are we ready? Let's get on the record. Go ahead.
Thank you. Good almost afternoon, Mr. Goggin. We met at the Paris race hearing. Do you remember that?
Yes, I do.
And you provided some testimony about a few different topics at the Paris race hearing. Recall that?
Yes.
So I just want to start like I did at the Paris race hearing with some of your live testimony today. Are you a meteorologist?
No, though I've taken coursework in atmospheric sciences, wrote my undergraduate thesis on climate change and climate science, participated in a National Science Foundation funded fellowship on climate science in my undergraduate years. And then in the intervening 20 years, as part of my job, I've stayed current on the literature regarding atmospheric sciences and wind and solar generation.
I'm sorry, regarding what sciences?
Atmospheric sciences.
Thank you.
And wind and solar generation, because this is a key part of my job and being knowledgeable about wind and solar power and their reliability and contributions to resource adequacy.
Your Honor, we got into this a little bit in the Paris race hearing, but that was a yes or no question. I think if it would be appropriate for the witness to answer with additional context about his background on redirect, not on cross. But
okay, noted.
Thank you. You testified here today that you believe the science is highly uncertain about future weather patterns. Is that a fair summary of part of your testimony today?
The uncertainty is high regarding whether there's any positive or negative relationship between climate change and wind droughts or renewable droughts in the Midwest region.
And then you also testified that you think polar vortexes are a once-in-a-lifetime event for wind resources. If the science is so uncertain, how can you be so definitive that those would only happen once in the 30-year lifespan of a wind resource?
My statement was that the temperatures would typically go below the minimum operating temperature once in a lifetime. I didn't mention polar vortex being a once in a lifetime event.
Okay, well, you talked about how the polar vortex had temperatures below that level. Can't that happen again next year?
It could. It's statistically unlikely to happen next year. The atmospheric sciences around the frequency and magnitude of polar vortex events is also somewhat uncertain. Certainly, the warming of the climate is going to reduce the severity of extreme cold in general. These, more complex interactions and, polar vortex type events are more complicated and more uncertain.
Are you aware that there are studies talking about heightened severity of storms as a result of climate change?
Yes.
What's the typical operating minimum temperature for a wind resource?
It depends on the manufacturer, but in general, and also it's generally around -20 degrees, and those are, I forget if it's Fahrenheit and Celsius. They're about the same once you get down to that range, but it's in that general range is my recollection is for the operating minimum.
Okay, have you done anything in your testimony in this case to predict when -20 degree temperatures occur in Wisconsin?
No.
And then you testified a little bit about Mr. Arndt's rebuttal testimony. Your Honor, if you could bring that up. Now I'm going to forget exactly where the page number is, but I can find it, I think.
Can give me a keyword I can search on the screen.
Yeah, page 2. Thank you, Your Honor. I think you do have it up. So you testified about this a little bit in your rebuttal testimony. Do you recall that, Mr. Goggin?
Yes.
And I think if you scroll down to the top of page 3, the answer continues, Your Honor. And if you could see the footnotes. The last line in that Q&A is, as Mr. Gerlikowski testifies, the OCCT project provides these benefits at significantly less cost than an equivalent amount of wind generation. See that sentence?
I see that statement, yes.
Did you review Mr. Gerlikowski's testimony as well?
Yes.
Okay, so you reviewed, and the footnote there is rebuttal WEPCO Gerlikowski 2 to 3. See that?
Yes.
Your Honor, if you could bring up Mr. Gerlikowski's testimony at 2 to 3. So you reviewed this testimony, Mr. Goggin, as part of your testimony in this case?
Yes.
And Your Honor, if you could just scroll to page 3. So the sentence there is, Mr. Burgess is arguing that Wisconsin Electric may be able to replace a 220 megawatt CT unit that costs approximately $240 million with over 1,050 megawatts of wind that would cost upwards of $3.4 billion. Do you see that testimony?
I see that statement, yes.
Let's go off the record for a second. You're fading in and out, Attorney Proctor Brown. Maybe moving that mic a little closer this time. Yeah.
Sure. I think that Q&A is concluded, right, Your Honor?
Yeah, the witness answered. Yeah, I was waiting for that. All right, get back on the record.
Thank you. And I believe your testimony today is that there is also energy value from wind, and so there may be some value on the energy side for this sort of a partial replacement. Is that a fair summary of your testimony today?
Certainly, it's not just some value. There's quite a bit of value that wind energy provides.
Sure, but setting aside the energy value, do you dispute the basic math here that Mr. Gerlikowski lays out, that Mr. Burgess is arguing a partial replacement of a 220 $40 million CT unit could be replaced by a $3.4 billion wind resource?
I'd make a few points. One, nobody is proposing that the resource be, or at least I'm not proposing that the resource, that the Oak Creek be solely replaced by any one solution. As I, and other Clean Wisconsin witnesses outlined, a portfolio of resources that includes wind, that includes batteries, includes demand side resources, is generally going to be cost effective at providing both energy and capacity. And that's the key point here, is that determining the cost of ratepayers is a co-optimization to minimize the total cost of energy and capacity. And looking at the cost of capacity in an isolation is not a meaningful exercise.
Right, but that's what the commission has to do when it approves individual resources, right? Is it has to approve given resource at a given price. Would you agree with that?
Objection, calls for legal conclusion.
Withdrawn. So Mr. Burgess and Mr. Kurlikowski are not analyzing here a complete replacement. They're analyzing the replacement of a single unit of 5 at the OCCT project. Isn't that right?
I didn't review Mr. Burgess's testimony in detail, but that it appears that's what Mr. Kurlikowski is setting up here. But per my previous answer, I don't believe that's the right way to look at this. The way that you can't separate the energy and the capacity value of resources, and your goal should be to minimize the total cost of meeting the ratepayers' needs for energy and capacity. So looking purely at capacity is not a meaningful exercise.
But you agree that the construction costs of wind resources are significantly higher on a per kilowatt basis than the OCCT project, right?
That's what Mr. Kurlikowski has put forward here. I didn't look at that in my testimony.
So you have no basis to dispute Mr. Kurlikowski's testimony that replacing a single unit of the OCCT project with a comparable wind capacity resource would be 15 times more expensive. Isn't that true?
I mean, doing the math here, this looks like it's based on an assumption that wind cost over $3,000 per kilowatt, which is much higher than industry averages that I've seen in recent years. So I'm skeptical of these numbers, but it was not within the scope of my testimony to do that economic analysis.
Okay, thank you. I believe you just stated too that you're not proposing to replace the OCCT project with any one particular resource, right?
Well, my testimony itself didn't propose any portfolio. The other Clean Wisconsin witnesses did kind of build those portfolios.
Is it your position personally that, and on behalf of Clean Wisconsin, that energy efficiency and demand response are potential alternatives to the 1100 megawatt OCCT project?
I think they would be part of a portfolio of cost-effective energy and capacity resources, but it was not the scope of my testimony to develop that portfolio.
So you said part of, so the corollary there is energy efficiency and demand response cannot solely on their own replace the need for the OCCT project, right?
As I said previously, I don't think that's a meaningful exercise to use any one resource to meet capacity and energy needs. Those needs are most optimally met generally through a portfolio of resources, reflecting that some resources are better at providing low-cost energy, like wind, whereas other resources are better at providing low-cost capacity, like batteries.
Right, and you have testified a couple of times about the portfolio, but I want to be specific about this particular resource. You do not believe the 1100 megawatt OCCT project can be replaced solely by energy efficiency and demand response, right?
I wasn't asked to evaluate that. I'm not an expert on energy efficiency and demand response. And it would be a question of, the economics. Does it make sense to do that? And in general, a portfolio is going to be a more attractive solution.
Right, and you keep talking about a portfolio, but I don't, that's not my question, and I don't need an answer to a question not posed. Do you personally believe that the 1100 megawatt OCCT project can be replaced solely through energy efficiency and demand response?
It wasn't in the scope of my testimony to look at that. It's probably feasible. It's a question of the economics, and a portfolio is going to generally be cheaper than using any one solution.
It's fair to say Wisconsin Electric has developed a portfolio of generation resources through the generation reshaping plan, right?
That's correct.
Thank you. I want to go back to reliability real quick. I'm not going to do a whole lot of back and forth on this, and I would ask you just to pay attention to my questions and answer just the questions posed, so we can kind of get out of here for lunch. Is that fair?
Sure.
We just looked at Mr. Arndt's rebuttal testimony. You also reviewed Mr. Arndt's rebuttal testimony, right?
Yes.
Your Honor, if you could bring up page 13 of Mr. Arndt's rebuttal testimony.
Should have it here somewhere.
Expects that's true.
Rebuttal.
Yes, please. Mr. Goggin, fair to say that both your and Mr. Arndt's testimony in this docket quite similar to the testimony that was presented in the Paris-Rice docket, right?
With regard to these issues relating to NERC, yes.
And during the Paris-Rice hearing, you reviewed Mr. Arndt's testimony in some detail during your testimony. Would you agree with that?
That's correct.
Okay. I'm going to ask you some hopefully straightforward questions. This part of Mr. Arndt's testimony is discussing reliability concerns expressed by the North American Electric Reliability Corporation, otherwise known as NERC, Reliability First, and MISO, right?
That's what he's talking about here, yes.
And what is NERC to your understanding?
It's the North American Electric Reliability Corporation. It's the entity that the Federal Energy Regulatory Commission has designated as the Electric Reliability Organization, and it sets and enforces mandatory reliability standards on the North American bulk power system.
And you testified in the Paris-Rice docket that over the past 15 years or so, you've been fairly heavily involved in issues of reliability at NERC. Is that an accurate summary?
That's correct.
So you would agree that NERC's mission is to assure the effective and efficient reduction of risks to the reliability and security of the grid, right?
That sounds reasonable, yes.
Would you agree that NERC is a credible source on the issue of grid reliability?
Yes.
What is reliability first to your understanding?
It's one of the regional entities that NERC has designated to assist with NERC standard compliance, as well as compiling regional information.
So they're the regional organization for reliability and security of the electric grid under delegated authority from NERC, right?
That's correct.
And they cover this area of Wisconsin, right?
Yeah, the eastern part, that's correct.
Do you consider MISO to, do you consider reliability first to be a credible source on issues of grid reliability?
Yes.
Do you consider MISO to be a credible source on issues of grid reliability?
Yes.
And I believe your testimony in the Paris-Rice docket was that, and I think you testified in some of your written testimony in this docket too, that the new administration under President Trump have dimmed the prospects for some of the environmental rules, and that may have changed the environment for reliability. Isn't that true?
That's correct.
And in fact, while during the Paris-Rice docket, you couldn't identify any administrative change that had occurred. At that point, yesterday, on March 12th, the EPA announced some formal undertaking to review some of the environmental regulations promulgated under President Biden. Is that true?
That's correct.
And the title of EPA's press release, if you'll accept my representation, is Trump EPA announces reconsideration of Biden-Harris Rule Clean Power Plan 2.0 that prioritize shutting down power plants while raising costs on American families. Do you have any reason to doubt that representation?
That's what EPA said.
And those, and fair to say that those greenhouse gas rules and some of the other regulations from the Biden administration provided incentives for renewable resources like wind, right?
It wasn't a direct incentive. If you're regulating the emissions of fossil resources or increasing their costs, then that can indirectly serve as an incentive for non-emitting resources. But there were no direct incentives for renewables under the EPA rules.
Okay, so I believe your testimony just now is that those EPA rules placed restrictions on resources like the OCCT project. Is that a fair summary?
Yes, among other things.
And one of those restrictions would have been on the capacity factor of the OCCT project as a peaking resource, right?
That's correct.
And so as we sit here today, the Trump administration has not withdrawn the greenhouse gas rules, right?
That's correct.
They've just begun the process that you have to undertake under the Administrative Procedure Act to begin reviewing what to do next, right?
That's correct.
And you've been involved in the industry for, you said at least the last 15 years, right?
That's correct.
And so you were aware of the promulgation of the Clean Power Plan 1 under President Obama, right?
Yes.
And that regulation ultimately didn't go into effect because of legal action in the courts. Is that a fair statement?
Legal action and then the Trump administration's attempts to withdraw it.
Yeah, and you say attempts to withdraw it because those attempts were ultimately a legal non-event, right?
That's my recollection. Yeah.
And as we sit here today, the climate regulations under President Biden are still the law of the land and have not been stopped or suspended by the U.S. court system. Do you agree with that?
Not yet.
And the history of the Trump administration's previous regulatory attempts in this area were ultimately ineffective as decided by the U.S. courts, right?
That is correct. The Trump first administration's ACE plan was struck down by the courts, but as we just noted, the Obama Clean Power Plan never took effect either.
So can you, as you sit here today, do you have any ability to predict the outcome of the Trump administration's administrative actions that were announced yesterday?
Not with certainty, but I believe my point is still valid that the prospects for the full implementation of the Biden greenhouse gas rule is significantly dimmer than it was prior to the election.
And your testimony is also that those greenhouse gas rules place restrictions on projects like the OCCT project, right?
That was one thing it did in regulating new gas, but that same new gas rule also would have limited other capacity resources from other gas generators in MISO. The existing rule under Section 111D of the greenhouse gas rule would have limited emissions or forced the retirement of coal generators that are a large share of the existing MISO fleet. And in WEC's application, it was the discussion of those aspects of the rule that WEC was alleging would contribute to a capacity shortfall in MISO. And so if those rules do not come into effect, then I think that would lessen that concern that WEC has expressed about a capacity shortfall in MISO.
Is it Clean Wisconsin's position that coal units should not be retired on the currently announced schedule?
That's not their position.
I'm sorry, the objection?
I was going to object that the witness can't speak to Clean Wisconsin's position on that. It wasn't in his testimony.
He obviously has knowledge of it. He just answered.
I'll draw.
Yeah, I think he can answer to the extent he knows.
I don't know Clean Wisconsin's position. I wasn't attempting to state that. What I was stating is simply the facts of what the EPA rule would have required. I'm not making a normative statement of good or bad.
Okay. But the fact is that regulation is currently on the books and needs to be complied with, right?
So far.
And if it's lifted, the direct impact on the OCCT project would be to allow the project to generate more energy at a higher capacity factor. Would you agree with that?
The new gas, if the new gas.
Wait, just going to interrupt here because I don't know if we know what would be rescinded exactly. I mean, it's kind of a speculative in terms of what would be rescinded, what would the terms and conditions of the new rule be. So if there's another way to ask that, or I don't, yeah.
He already testified that it's a restriction on emissions if that restriction on emissions is lifted. So I can rephrase.
Okay. Yeah, more particular to the lifting of a particular restriction. Sure, that would be.
So Mr. Goggin, you testified one part of the Biden administration's greenhouse gas rule is to limit the emissions on new gas like the OCCT project, right?
That's one part, yes.
And if that particular part is lifted, the direct impact on the OCCT project would be to allow it to produce additional energy for Wisconsin customers, right?
That would be allowed if that one provision were lifted. The total net impact of the greenhouse gas rules is much more complicated because it would require looking at the dispatch of Oak Creek relative to other generators in MISO. And yeah, as we just talked about, that affects both new gas throughout MISO as well as existing coal and steam generation throughout MISO. And, taking away those rules could have a positive or a negative effect on the operation of Oak Creek.
So fair to say there's significant uncertainty, but Wisconsin Electric and other utilities have to comply with the greenhouse gas regulations as they exist today, right?
They have not the compliance timeline and requirements have not yet come into effect, and many of them don't kick in until the next decade. Yes, the rule is still the law of the land, but there's not really any binding requirement under the rules yet.
Okay. I want to go back to some statements you made about the polar vortex. Do you have that in mind?
Sure.
You referenced some impacts on natural gas units. Do you recall that testimony?
Yes.
Do you have any specific knowledge about Wisconsin Electric's natural gas generation fleet?
I may have learned some through the course of this case and through discovery in this case.
Are you aware of any of those negative effects that you referenced occurring to Wisconsin Electric's natural gas generation fleet during the polar vortex?
I don't have that specific information. I didn't testify to it.
And so if I represented to you, and other witnesses could testify about it, that Wisconsin Electric's natural gas generation fleet operated reliably during the polar vortex, you'd have no reason to dispute that testimony, right?
Objection, Your Honor. That's the counsel trying to testify on behalf of his client. If they want to get that in the record, we can have a witness say it.
Your Honor, we went into this earlier. Mr. Corte is making totally invalid objections to me asking very specific cross questions.
Okay. Unfortunately, you have to read that back from the rule.
So I've represented to you and other witnesses could testify about it that Wisconsin Electric's natural gas fired operated reliably. Do you remember the polar vortex? You'd have no reason to dispute that testimony.
Okay, well, in light of that recitation of the record, let's have you restate that question because I don't understand what was said.
That's fair. Mr. Goggin, you have no specific knowledge of the operation of Wisconsin Electric's gas fleet during the polar vortex, right?
That's correct.
So you could not dispute testimony that said Wisconsin Electric's gas fleet operated reliably during the polar vortex, correct?
Objection. There
That's
is no
assuming-
testimony.
That's assuming facts not in evidence.
That's fine.
Okay.
Mr. Goggin, you would agree that the performance of natural gas generation generally is variable and based on how those units are constructed and maintained, right?
That would be one factor.
So your testimony about natural gas units having reliability problems during the polar vortex or any weather event does not incorporate any knowledge that you have about how Wisconsin Electric operates its natural gas generation units or maintains its natural gas generation units, correct?
It wasn't intended to be a specific statement about their fleet. I mean, the fundamental physical factor that things break when they get cold is real.
Yeah, and you'd agree Wisconsin Electric has been operating in the cold here in Wisconsin for quite some time, right?
Sure. Yeah, that's fine.
Thank you, Mr. Guy, and appreciate you testifying today. We've spanned into the afternoon, so I hope you have a good afternoon. That's all the questions I have.
All right. Any other cross for this witness? No? How about redirect?
No redirect, Your Honor.
Okay. So let's go off the record for a second. I guess we are in time for a break. I thought we'd get another witness in. We'll take a shorter break so we can move on. But I just was curious, and I know we have the a declaration, well, not a declaration, well, basically a press release, a video from Administrator Zeldin of the EPA announcing the reconsideration of these Biden era rules. Is that the extent that we have documentation about that? It's like on their website, it's just a press release. Is that all that exists currently that parties know about? There's nothing more official.
Your Honor, there is the executive order. I mean, there's nothing in the record because it all happened after the deadline yesterday. So,
right. Yeah, they don't
but
link because there's no link on the EPA website to the executive order was earlier talking about removing promoting oil and gas.
No, that's one executive order, Your Honor, that we referenced in the earlier testimony. My understanding is there's an executive order that was issued yesterday that has multiple different parts to it. And so I think this announcement that I was referencing refers to one part of the executive order.
Oh,
it was kind
okay,
of all
right.
put out in a package yesterday. I don't think anybody's digested all of it, to be honest with you, Your Honor.
Okay, yeah, I did see there was a link to a number of historic actions. It said, okay, yeah, that doesn't give us any documentation. Well, I'm just gonna let it go. I think we described the impacts of what we know of. So rolling something else in that might not be relevant, it's not gonna be worthwhile.
Yeah, I agree with you, Your Honor.
So we're done with last witness, and we can break for, I'm going to give you a 20-minute break. We'll head back with the rest of our, or are we going to be taking Sherwood?
Yes, Your Honor.
Yeah, okay. Well, yeah, we'll continue with Sherwood next. Okay, all right, we'll take care. So 20 minutes will bring us to 12:35. No, 12:45.
Thank you, Your Honor.
All right, great. All right, it's 12:45, so let's get back on the record. We'll just need witness Sherwood.
I'm here.
Okay, not seeing you. That could be my problem here. Yeah, why did that change? There we go. Okay, let me just get you all set up on my screen. Great, I think we're good. Okay, and excuse me. All right, let's get on the record. I'll swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead with this witness.
Thank you, Your Honor. Good afternoon, Ms. Sherwood. How are you?
Doing well.
Could you please state your name for the record?
My name is Stacy Sherwood.
And Ms. Sherwood, are you the same Stacy Sherwood that prepared and caused to be filed direct and surrebuttal testimony and 16 associated exhibits in this docket?
Yes.
To the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes, they are.
And do you have any corrections to your testimony that you'd like to offer today?
No, I do not.
Thank you, Ms. Sherwood. There have been questions posed by counsel for the applicant to several witnesses during this hearing, including to Mr. Jester this morning, about the ways energy efficiency and demand response programs can achieve savings. Have you followed the testimony so far in this hearing?
Unfortunately, yesterday I was unable to attend the hearing, but I did hear all of the testimony today, including Mr. Jester's.
Great. So, Ms. Sherwood, in this case, you presented testimony about energy efficiency and demand response resources, specifically identifying 10.9 megawatts of cost-effective energy efficiency program savings, a residential demand response program offering 62 megawatts, and a behavioral program offering between 54.1 megawatts in the winter and 83.8 megawatts of summer demand reduction. Is that correct? Are those figures correct?
Yes, they are.
Do you have familiarity based on your professional experience about how programs could be successfully deployed to achieve the savings you identified?
Yes, there's several factors that can affect the success of energy efficiency and demand response programs.
And could you briefly explain what those factors are?
Sure, there's several factors, but I think I'll stick to a couple just for brevity.
I just need to interrupt a sec. Is this reviewing what's currently on file, or is this going to be additional testimony?
This is not, this is Cercer on the stand, Your Honor.
Right, but it's not just repeating what's already been offered?
Correct.
Okay, all right, go ahead.
One of the first items I would say is comprehensive program design. So offering measures, they can be individual measures up to a comprehensive deep retrofit design that varies for both residential and commercial customers and industrial customers as well sometimes. Another way that you can affect the effectiveness of the program are incentives and financing offers. So on the incentive side, you don't want to incentivize too much. So you have to kind of find that sweet spot, but you can use levers to change the incentives from time to time to create greater participation or lower participation, depending on the level of demand in the programs. Also offering financing opportunities for those who may not be able to afford the whole project upfront, both on the residential and the commercial side. And then I would say for program success, you also need to have good marketing and outreach that's occurring. You need to have engagement with stakeholders in the process, which would also include potential participants in the program. And then education and training for both contractors that help support the programs, but also for participants.
Thank you. And based on everything, the record in this proceeding, do you have an opinion as to whether there's additional capacity in Wisconsin for significant expansion of energy efficiency and demand response programs?
Yes, in my opinion, I do believe that there is additional expansion of both energy efficiency and demand response for all of Wisconsin. We see that through the market potential study that was conducted for the Focus on Energy programs, but also when you look at the American Council for an Energy Efficient Economy. They indicate that Wisconsin ranks 26th amongst all the states in terms of energy efficiency, and in terms of retail sales or energy savings compared to retail sales in the state of Wisconsin, it actually performs lower than most of its surrounding states. And so to me, that indicates that there is ample opportunity to increase.
Thank you, Ms. Sherwood. Witness is available for cross.
Do we have any questions?
I do, Your Honor.
Okay, let's go off the record a second. I'm just gonna bring you up here. Now it's Attorney Proctor Brown who just spoke.
Yes, Your Honor. I do wish my name was spelled with an E. I could have some, fun serial swag, but it does have an O.
I got it right though, didn't I? Or you got? I got it right on the screen.
No, you have it with an E, like Procter and Gamble. So my joke is
okay.
always
Okay.
I'm not a Procter and Gamble heir. Sorry.
Well, we can always hope.
Right.
All right. So I think we're good to go. Proceed with your cross.
Thank you, Your Honor. Ms. Sherwood, do you recall testifying in the Paris? My apologies. Ms. Sherwood, my name's Patrick Proctor Brown. We met during the Paris Rice hearing about a month ago. Do you recall that?
Yes, pleasure to see you again.
Good to see you too. Thanks for coming this afternoon. And I asked you some questions about energy efficiency during that proceeding, right?
Correct.
Is it your position in this docket that energy efficiency and demand response are potential alternatives to the entire 1,100 megawatt OCCT project?
No, and that has never been my position in this project.
Thank you. You mentioned two bases for your position that there's additional demand response or energy efficiency available in the state of Wisconsin. First was the focus on energy potential study, and the second was some information from the ACEEE. Is that a fair summary of your testimony today?
Yes, that is correct.
And fair to say that ACEEE is an organization that's dedicated to supporting energy efficiency nationwide, right?
Yes.
Is there anything, have you done anything specific to Wisconsin yourself or Wisconsin Electric Service Territory to evaluate the potential of energy efficiency or demand response?
I did not perform a formal demand response, but I looked at records that would support it, including EIA documentation, which I have referenced in my direct testimony, to evaluate whether or not, based on my prior experiences elsewhere, that Wisconsin, and specifically WEPCO, could have additional energy efficiency and demand response opportunities.
All right, and based on your experience, elsewhere you listed some requirements for a successful energy efficiency program. Is that a fair summary of your testimony this afternoon?
Yes.
It's fair to say you haven't done anything to evaluate how those various requirements would be implemented here in Wisconsin, right?
I have not put together a plan, but I did put forth in my surrebuttal testimony that I believe the additional savings could be achieved by WEPCO itself implementing additional energy efficiency programs and not just through the focus on energy effort. I did not propose an entire plan to support that.
You didn't talk about the timeline or costs or any of the requirements that Wisconsin Electric would need to do to put together that energy efficiency and demand response program, right?
Are you referencing the cost to develop that or the cost for the program itself?
The cost to develop it.
No, I did not put forth any recommendations related to that.
But fair to say there would be costs associated with developing an energy efficiency and demand response program, right?
Yes, typically those costs, though, are spread over the life of the first portfolio span, which is typically 3 to 5 years timeline, depending on the service territory. And so those costs spread over the time are actually included in the overall cost of the programs and included in like the cost per megawatt. The assumptions that were used by Witness Hoteling.
And those assumptions were provided by you, weren't they?
Yes, they were, but they were based upon using costs in other states, as well as the ones provided in the market potential study.
Right. So no costs that you developed yourself, the costs from other states and from the potential study from Focus on Energy, right?
Yes. So what I would characterize that as, while I may not have done it, I use best practice to guide that logic.
And fair to say the Focus on Energy potential study is developing costs for the Focus on Energy program to implement those programs, right?
Correct, which is why in my assumptions, I used a conservative value of what could be achieved, recognizing that there would be administrative costs associated with the utility implementing the program instead of Focus on Wisconsin, which takes into account that they're already administering a program.
Right. And again, it's not your testimony or testimony of any Clean Wisconsin witness that energy efficiency and demand response on their own are a feasible alternative to the OCCT project, correct?
That is correct. It'd be a portfolio of resources.
Thank you. That's all I have for you, Ms. Sherwood. Appreciate your testimony today. Thanks.
Okay. Any other cross for this witness? Hearing none. Redirect?
No redirect, Your Honor.
All right. There we go then. Thanks very much. You're excused.
Thank you.
Okay, is that all of the Clean Wisconsin witnesses?
Yes, Your Honor. And could I make a request of you off the record, please?
Yeah, well, sure. Let's go off the record. See what you got.
I just have a prior commitment later this afternoon, and I'm asking to be excused around 4 o'clock, and Attorney Nicola will take over our representation for the duration of today, at least.
That's fine. Yeah. Let me say, I think I've gotten a number of those requests. As long as you have some attorney to sit in, I know a lot of people have doubled up. That should be fine. You don't need to ask for leave in that case, as long as we have a witness, as long as we have a representative from each party. Otherwise, if a party does have a conflict, let me know. It's not a big deal, but I'll just note that, in my own mind that you're not here. So yeah, it's okay if you have someone to back you up. Just proceed without requesting any permission, I guess. So let's get back on the record. I think we're up with witness Nunez from Healthy Climate Wisconsin and Union of Concerned Scientists next.
Yes, thank you, Judge Newmark. Healthy Climate Wisconsin and Union of Concerned Scientists call Dr. Yaneli Nunez to the stand.
Okay, I wrote that, but who said that?
Yeah, let me get off the record. So that was Grant Snyder, the attorney for...
I see.
Yeah, I don't know if this matters for you, but I'm going to put a pin in that. And then your witness...
I'm here.
Where are you? Yes, I'm going to find you. Don't worry. There we go. All right, I think we have everyone where they're supposed to be. So let's get started. I'll swear you in, Dr. Nunez. Raise your right hand. Do you swear or affirm tell the truth, the whole truth? Sorry. Do you swear to affirm? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead.
Dr. Nunez, did you prepare or supervise the preparation of the written test marked as direct HCW UCS Nunez, rebuttal HCW UCS Nunez, surrogate HCW
I'm sorry.
UCS Nunez?
I don't know if it's my computer or yours, but that all was kind of garbled.
Is it better now?
It's
like it would be. Oh, it wasn't just me then. 3 or 4 words would be good, and then there was a garbled.
It wasn't just you. Yeah, it's you're a little choppy on your connection.
Is it better now? No.
No, it's so far. It seemed to happen. We'll just take it from here and see how it goes. But yeah, it's kind of hard to tell.
Can you start that over?
Okay. Yes, I will start it over.
Okay. Try it again.
Dr. Nunez, did you prepare or supervise the preparation of the written testimony marked as direct HCW UCS Nunez, rebuttal HCW UCS Nunez, Sir rebuttal HCW UCS Nunez, and Sir rebuttal HCW UCS Nunez with 7 associated exhibits in this proceeding on behalf of Healthy Climate Wisconsin and Union of Concerned Scientists?
Yes, I did.
In reviewing your testimony in preparation for cross-examination, did you find any errors in your testimony that required changes to those pre-marked exhibits that you would like to make at this time?
Yes, one correction. While reviewing witness coerced or rebuttal, I realized that I cited the wrong table from WEPCO's application in my direct testimony in reference to where PSE obtained the project's operating emissions. In my direct testimony in page 7, line 5, I referenced table 5-9 from WEPCO's application as our source when it should have been referencing table 5-6. And that error appears to have caused confusion regarding whether PSC double counted shutdown and startup emissions. However, we use the correct emissions operating rates from table 5-6 and the shutdown and startup emissions from table 5-7 in the report analysis.
Okay, so let me just make that clear for me. Is that on your direct?
Yeah, in my direct and page 7, line 5. So here it says from table 5-9 and line 5. Yes, exactly, right there. But those emissions were actually, like the operating emissions, those were actually from table 5-6.
Okay, so you're going to change the 9 to a 6. Okay, that's great. So we'll need you to refile your testimony with that correction in addition to the other comments that we made here. Okay.
We'll plan to do so, Judge Newmark.
Okay, yeah, thanks.
Okay, apologies about that.
It's all right.
Notwithstanding that correction, are the facts that you state in testimony true and correct to the best of your knowledge?
Yes, they are.
Do the opinions and conclusions expressed in your testimony reflect your professional experience and best professional judgment?
Yes, they do.
No further questions. This witness is available for cross-examination.
Okay, I just wanted to mention, does HCW UCS intend to file that Nunez 8 exhibit?
Yes, we'll be filing Nunez 8.
Okay, just want to confirm that. Okay, great. All right, so let's have WEPCO. Any cross at this time?
Yes, Your Honor.
Okay, go ahead.
Good afternoon, Dr. Nunez. My name is Joe Wilson, and I'm one of the lawyers representing Wisconsin Electric Power Company in this case. How are you?
Good. Very nice to meet you.
Nice to meet you. Dr. Nunez, you have not testified before the Wisconsin Public Service Commission before, have you?
No, I have not. This is my first time.
And you haven't worked on any projects in Wisconsin before this one, have you?
No, I believe this is my first project in Wisconsin. Correct.
In reviewing your resume, which is Exhibit Nunez 1, it appears that you perform policy-driven research in climate, energy, environmental health, and environmental equity using data science and applied statistics. Is that an accurate characterization of your current job?
Yes, I am an environmental health scientist and I work in an independent research institute, and we do focus on action-driven science. So our goal is to provide analyses that are relevant and informative for the policy space. Yeah.
In your professional career, do you have any experience calculating emissions from industrial sources?
My area of expertise is in environmental health sciences. For my doctoral training, my postdoctoral training, my focus was in evaluating the effects that long-term exposure to air pollution has on human health.
particularly concentrating on low levels of exposure like the ones that we have here in the US. So I have extensive experience studying air pollution exposure and health.
Have you yourself, though, calculated air emissions from industrial sources?
That's outside the area of my work and my expertise and what I submitted in my testimony.
Okay, so that's a no, correct?
Correct.
And presumably you don't have any experience preparing or submitting air permit applications for power plants, do you?
I have reviewed the applications. I reviewed some. No, that was a CPCN application. Yeah, I don't have extensive experience reviewing air permit applications.
You've never been to the Oak Creek campus, have you?
No, I live in New York. So
have you ever testified in favor of natural gas fired generation?
This is actually my first time testifying, so no.
Have you, well, welcome.
Thank you. Hope it goes smoothly.
Have you prepared reports that favored natural gas fired generation or urged a regulatory body to approve a natural gas plant?
As I say, I am a scientist working at an independent research institute, and my work is not to favor one party or another one. My work is to do science and to present the data and analyses as they are without having any size, if I make sense.
But in this case, you do urge the commission to reject the Oak Creek CT project, right?
Based on the results from the analysis that we perform, I provide that recommendation. So my recommendation is based on the evidence from for the report and the analysis that we did, evaluating the health and economic impacts associated with emissions from the proposed gas power plant.
Have you reviewed the Oak Creek CT air permit application?
I reviewed the Oak Creek CPCN application.
Okay, but you have not reviewed the air permit application?
Not for this case, no.
Okay, so that's a separate application to the Wisconsin Department of Natural Resources. You've not reviewed that in any way?
No, the focus of this study was using emissions data reported in the CPCN application.
Do you consider the Wisconsin Department of Natural Resources to be a credible source on issues concerning air emissions?
I will say I do. Yeah, I haven't worked with them. I don't have much experience interacting with it, but I will assume they are, yes.
I'm going to call them the DNR for short, okay?
Okay.
And is it your understanding that they've reviewed the air permit application for this project and agree with the emissions analysis outlined in the application?
I read that in some of the other witnesses' testimony.
And you don't have any reason to dispute witness Corps' testimony on that point, do you?
No, that wasn't the focus of the analysis that we did or the testimony. The analysis was not to determine whether the air permit decision was appropriate or not, or whether the project meet any of the air quality regulatory regulations.
Sorry, the air quality
regulations.
Thank you.
That wasn't the purpose of our analysis.
The emissions analysis from the application, which was which has been also reviewed by the DNR, shows that this specific project will result in overall net emissions decreases for all pollutants except VOCs, correct?
In our analysis, we specifically evaluate the emissions associated with the proposed natural gas power plant. We did not do like a comparison. We didn't, it was outside the scope of our analysis to determine whether this was a replacement or not. We are specifically analyzing, or we specifically analyzed the emissions associated with the proposed gas power plant.
You've taken the position in your testimony that this project is not a replacement for the existing coal-fired generation at the site, right?
It is my understanding that the coal units were already scheduled to retire in this year, and it is my understanding that the project, the proposed gas power plants, are scheduled to open in late 2027 or early 2028. So also, since the coal units were already scheduled to retire, overall, the lifetime emissions will be increasing because the average life expectancy of a gas power plant, it's about 30 years. So this is my understanding of the situation.
When you say that's your understanding, is it fair to say that that's your belief and it's not necessarily based on interpretation of air emissions statutes or regulations?
That's my understanding based on the information that I have. But once again, like the focus of my testimony and the analysis was to evaluate the health and economic impacts associated with emissions from the proposed gas power plant, regardless of whether it is considered a replacement or not.
But the results in terms of health impacts and economic impacts that were the headline for your report relied on an assumption that the OCCT project was not a replacement for existing coal units, right?
I use the emissions that were provided in the CPCN application.
Okay. So can you answer the question I asked?
As I say, like we analyzed the emissions that were specifically associated with the proposed gas power plant using the emissions that were reported in the CPCN application.
You're still not answering the question that I'm asking. I understand that that's your position, but I have the ability today to ask questions and you need to answer them if they're not objectionable.
Can you repeat your question?
Let's read it back.
Question, but the results in terms of health impact and economic impacts that were the headline for your report relied on an assumption that the OCCT project was not a replacement for existing coal units, right?
I will say that for our analysis, it was irrelevant. Like we specifically analyzing the emissions from the proposed plant. So we don't like it's irrelevant whether this is considered a replacement or not. Like you can go further and say, okay, we want to analyze the emissions from the natural gas power plant and we want to analyze the emissions from the coal power plant, and that will be like a different study and a different analysis. For this study, we specifically analyzed the proposed natural gas power plant.
And you did not analyze the health impacts and economic impacts, assuming that the natural gas fired project was a replacement for the coal plant, correct?
Asked and answered.
What?
Asked and answered. She said she didn't.
Do you have any reason that believe that the Wisconsin Department of Natural Resources is conducting its analysis of the air permit in this case in a way that violates state or federal law?
No.
I don't have any
You
reason.
can't, she's not qualified to answer that.
I don't have any reasons to
No,
believe.
you can't.
that.
No, sorry. That assumes a legal conclusion in the answer. So, no.
Your Honor, her testimony is replete with citations to statutes and regulations. She's here providing this sort of testimony.
She
And she's
can't
an
testify
expert.
if something violates the law.
I
That's a
asked
legal
if she has.
conclusion, classic legal conclusion.
I asked if she has any reason to believe that the DNR is violating the law. Her testimony is replete with legal citations to statutes and regulations that govern how these sorts of analyses are done.
Attorney Wilson, can you point us maybe to one? Maybe that could assist in this process.
Please bring up her direct testimony, Your Honor. In the interest of time, I'll move on and perhaps come back to this.
Hey, we can revisit it.
All right.
You want?
You don't have any reason to dispute that Wisconsin Electric is retiring the coal units at the Oak Creek campus, do you?
Can you repeat that question? I got distracted.
Let's read it back.
I'm sorry.
Question. You don't have any reason to dispute that Wisconsin is retiring the coal units at the Oak Creek campus, do you?
No.
And you don't have any reason to believe that Wisconsin Electric is constructing any additional coal-fired units at the Oak Creek campus, do you?
Again, like my analysis evaluated the health impacts, the health and economic impacts of the plant, and I didn't did any sort of like research or investigation to gather information and be able to answer this question. It's based on what I know now, but I don't know extensively about this that you're asking me.
You're proposing that the commission undertake a different and new analysis with respect to air emissions than the WDNR is taking, right?
My testimony provides the results from analysis evaluating the health and economic impacts, and my request is that this evidence is considered or like is used to inform the decision. But I am not proposing a new set of analyses, or analysis was not to determine whether the current air quality regulations are appropriate or not, that that's not the scope of our work, that it's not what we focus our analysis on.
Have you reviewed Ms. Corr's rebuttal testimony? And Your Honor, can we please bring up rebuttal on page 3?
Let's go off the record for a second. Yeah, I'll get that.
Do you say rebuttal or rebuttal?
Rebuttal.
Page 3 you mentioned.
Are you familiar with this?
Wait. Are we back on?
I'm sorry.
Not yet. Okay, is that where we need to be?
Yes.
Okay. Are you ready, Dr. Nunes?
Yes, I am. Thank you.
Great. Well, let's get on the record.
Are you familiar with witness Corr's rebuttal testimony, Dr.
Yes,
Nunes?
yes, I am.
And you see at line starting at line 3, Ms. Core testifies that Mr. Munson's netting analysis is also consistent with state and federal regulations that govern how multiple projects on a single site during a short time frame are evaluated and permitted. Under the Clean Air Act and U.S. Environmental Protection Agency guidance, substantially related physical or operational changes at a facility are considered a single project for air permitting purposes. Did I read that correctly?
Yes.
You don't have any basis to believe that Ms. Corer is misrepresenting this EPA guidance, do you?
No, I don't think so. No.
And Ms. Corer continues, Wisconsin Administrative Code specifically requires a net emissions analysis of existing and new emission sources when a regulated pollutant may increase above the significant level as part of a new project. Did I read that correctly?
Yes.
And Ms. Corer cites a number of provisions from Wisconsin Administrative Code there, right?
Yes.
You don't have any basis to challenge Ms. Corer's interpretation of those administrative provisions, do you?
Objection. I think that this calls for a legal conclusion again.
Sustained.
Natural gas is cleaner in terms of air emissions than coal-fired generation, right?
Yeah, on average, natural gas power plants emit fewer concentration of pollutants relative to coal power plants. That is correct.
So from a public health perspective, as between a coal-fired power plant and a natural gas-fired power plant, you would prefer a natural gas-fired power plant, correct?
That is outside my testimony and the analysis that we did. Again, I'm not disputing that gas power plants have fewer emissions than coal power plants. We evaluated specifically the health and economic impacts associated with the natural gas power plants using the emissions reported in the application. Regardless, like our analysis is independent of whether the emissions meet any air quality regulations. And our analysis was not to determine whether the plant meets air quality regulations or not. It was to evaluate specifically the health and economic impacts associated with the emissions from the proposed natural gas plant.
Is it your position that the commission should consider health impacts associated with air pollution in deciding whether to approve the Oak Creek CT project, even if the DNR issues an air permit for the facility?
I think objection again calls for a legal conclusion to the extent that this is based in a requirement of the CPC law.
No, I don't think I would read it that way. I think the witness can answer what she intends the commission to understand, how she intends the commission to understand her testimony. That's a fair question.
Yes, I don't, it's not just the health impacts, but also the economic impacts associated with those health impacts. That is why in the report and in my testimony, I refer to the economic impacts. And as I mentioned earlier, this health and economic impacts are independent of whether the plant meets air quality regulations or not. I submitted one of my exhibits. Let's see what number it is. Exhibit 7 is an integrated science assessment for PM 2.5. This is a extensive, comprehensive review of all the existing scientific evidence evaluating the health effects of PM 2.5, and is put together by the EPA. And in this assessment, if you go to page 1-31 and 1-32, you will see there that after evaluating all the available epidemiological and toxicological evidence. The conclusion that is made based on existing evidence is that the effects of PM 2.5 are not threshold based. And what this means is that, to our knowledge, based on the scientific evidence, there is not a concentration of PM 2.5 that we can consider to not affect health or to not have health effects. Therefore, based on this evidence, in a situation where the plant meets air quality regulations, which I believe it does, based on the information provided by Correr and the other testimonies, we will still expect to see a level of health and economic impacts. And that's what our analysis is focusing on, using emissions provided in the CPCN.
Is PM 2.5 one of the emissions covered by the air emissions permit that's been sought in this case?
Yeah, PM 2.5 is a criteria pollutant, so I will assume it is.
And so would you also assume that Wisconsin regulations contain a maximum limit for emissions of PM 2.5?
I don't think she can answer. She hasn't seen the permit's in the record, isn't it? Didn't someone offer that recently?
I don't believe it is, Your Honor. The EA is in the record, but I don't think I could be wrong about that.
Let's go off the record. Yeah, I thought I'd seen it recently. Because if that's something we can refer to, that's fair. But I mean, this witness doesn't have any knowledge, and she's already established hasn't had knowledge of what's in the permit or what DNR is reviewing. I don't really think.
I didn't review any of those documents. I haven't seen.
We're off the record, just so you know.
Yeah.
Judge Newmark, in preparation for the hearing, I did not see the application in this docket.
Huh.
Yeah, Judge, you may be thinking of, we recently filed the notice that the air permit is out for comment. That's the stage it's at right now.
Right, it was like a initial determination, though, wasn't it?
Yeah, DNR's made an initial determination. Right. It's now up for comment.
And is that's offered as an exhibit?
Yeah, that's quarter 3, I believe. 2, excuse me.
Yeah, I just opened that. I didn't see it. Okay, let me check. Oh, yeah. No. What did I? So maybe I went further. Okay, so that's the only part. So there is a preliminary determination on the in that exists. I thought I'd seen it. Okay, well, I mean, let's have the question read back. The last question from Attorney Wilson.
And so would you also assume that Wisconsin regulations contain a max number limit for emissions of, and I wasn't sure of the exact letter, PM 2.5? Okay.
I think that calls for speculation, and she's not familiar
with
the
are we back on the record?
Yeah, let's get back on the record. So yeah, let's, in response to my interrupting the answer there, let's just hear from Clean first.
Sorry, Your Honor, from Healthy Climate Wisconsin, I assume?
Yes, right.
Yeah, okay. So, yeah, objection outside the scope of the testimony. Also, she hasn't seen anything, and there hasn't been anything presented to establish this conclusion. No document that was produced by Healthy Climate Wisconsin or UCS or sent to us by WEPCO gave an upper limit on PM 2.5 emissions.
Okay, any response from WEPCO?
Yes, Your Honor. So when I asked her, well, she previously testified, she assumed that PM 2.5 would be regulated as part of the air permit. I then asked, would she also assume then that Wisconsin regulations would contain some limit on PM 2.5 emissions, which she recognizes as a criteria pollutant?
calls for speculation for evidence not on the record. I mean, we don't have anything to she doesn't have any experience to say whether or not there's an upper limit in Wisconsin.
So I just don't want to get further down the road with trying to get her to confirm things that she's already said she has very little knowledge of, or in documents we haven't seen. I mean, there may be a logical conclusion here, but to rely at that conclusion as evidence is just unreasonable. So I don't think we can have an answer from this witness on that.
I have just 1 second, Your Honor. I want to look at something in the testimony here.
Mm-hmm.
Your Honor, maybe we go at this a slightly different way, and then I can move on. It's really just a pretty simple question.
Give it your best shot.
We can pull up Mr. Munson's direct testimony. There's a table on page 5.
Okay.
Dr. Nunez, are you familiar with the table we're looking at the bottom of page 5 of Mr. Munson's direct testimony?
Yes, I reviewed this in preparation for the cross-examination.
Okay. And what's your understanding of what this table is showing?
From my understanding, the column that it's labeled has a new project emission units refers to emissions from the proposed gas power plants, and then like the next column, the net emission increases. I believe Manson compares the emissions from the gas power plant to the coal power plant to estimate whether there will be an increase or decrease based on this comparison. And then I don't know what NNSR serious significant emissions rate. I don't know what it refers to. And then the PSD significant threshold, I believe that this is at the threshold that if it's above this threshold, it doesn't meet the regulation. Yes, so that is my understanding. So in this table, Mr. Manson compares like the difference from the gas and the coal power plant emissions, and then compares those differences to a threshold.
Mm-hmm. And do you understand the NSR stands for new source review?
She said she didn't. She said she didn't know what that was.
Okay. Well, all right.
I mean, that's what we have to do. We have to deal with what we have, and she said she didn't know. So,
can you go to page 1 of the testimony, Your Honor?
Well, we can tell her what it is now, but.
So I was trying to do.
Yeah, well, it doesn't really inform her question, though. Okay, go ahead.
Based on the definition at line 9 here on page 1, do you understand that NSR stands for new source review?
Testimony speaks for itself.
I see that it says there. But Attorney Wilson, again, in my analysis and in my testimony, the focus of our work was not to evaluate whether the proposed gas power plant will meet regulations or not.
Yeah, I think based on that answer, I'm going to say further questions along this line is unreasonable cross. Just not getting information that's valuable here, because we understand the position that the witness is in, and her expertise does not deal with the permitting process for air regulation. So let's move on with any other questions you have.
May I be heard on this, Your Honor?
Yeah, go ahead.
The witness, in response to an earlier question, had you pull up one of her exhibits that talks about the health impacts of PM 2.5. All I've been trying to establish with this line of question, which has been repeatedly interrupted, is that the DNR sets a limit and will be regulating PM 2.5 in this document. Will be issuing an air permit, assuming that the plant can satisfy emissions criteria for PM 2.5 and all other criteria for pollutants.
Okay.
I think I'm entitled to ask that question.
But it's already established in the record. There's no argument about that. And the fact that this witness knows or doesn't know about it is irrelevant. So I noted your objection, but I'm going to overrule and we're going to move on.
You familiar with Dr. Hall's rebuttal testimony?
Yes, I am. I can pull it up.
Judge Newmark, could you please go to page 4, Dr. Hall's rebuttal?
Sure.
Here, Dr. Nunez, Dr. Hall explains that the Clean Air Act requires the EPA to set NAAQS, or National Ambient Air Quality Standards, for 6 main pollutants, correct?
Correct.
And you don't have any reason to disagree with that, do you?
No, I know about the NAAQS. I know about the criteria pollutants. Yeah.
All right, in line 19, Dr. Hall says that, as noted by the EPA, primary standards provide public health protection, including protecting the health of sensitive populations, such as asthmatics, children, and the elderly. Secondary standards provide public welfare protection, including protection against decreased visibility and damage to animals, crops, vegetation, and buildings, right?
Correct. I see that.
Is that your understanding of what the NAAQS do?
Yes, that is my understanding. And in my testimony, I'm not disputing what the NAAQS do.
You've said, I think, multiple times that you used emissions for this project as reported in the CPCN as inputs for your analysis, and that analysis was the co-benefits risk assessment health impacts screening and mapping tool, which is the acronym is COBRA, right?
Yeah, we use operating emissions rate from table 5-6 from the application and scale those to annual tons per year using the 100% load column. And then to this annual operating emissions, we added the annual shutdown and startup emissions that were reported in table 5-7. After reviewing Correr's source rebuttal, I realized that the emissions that we use, those that were reported in table 5-6 and 5-7 from the CPCN application, didn't include some of the NOx emissions control regulations that Correr mentioned in her testimony. So after reading her source of rebuttal, I rerun the COBRA analysis using specifically the emissions from table 5-9, which are the ones that do consider the NOx emissions controls that were mentioned in Correr's source of rebuttal, and estimated the health and economic impacts using those emissions that do consider the NOx emission controls. And the difference in emissions was really minimal. So the health and economic impacts using this reduced emissions is pretty similar to the original health and economic impacts that we got in the original analysis that is in the PSE report. And I can read those numbers. So in the original
That's in testimony. We don't need to review it now.
Okay. The new results from like the lower emissions of NOx, those are not in the testimony. I can
Okay. Yeah, go ahead if there's some, well,
yeah, so that's 80, and the low level estimate is 80 million for the economic impacts. The high level estimate is 127 millions annually. It's about
Your Honor.
about 100 millions, which is very similar to what was
Okay.
estimates in the report.
Your Honor, we just on the stand learned about a whole new health impacts and economic analysis that hasn't been presented until now, which we don't have the benefit of having in front of us. And this is totally improper.
Yeah, I agree. I agree.
I'm gonna move to have the PSC report struck from the record. If it doesn't reflect their current analysis, it is not proper evidence for the commission to consider in this case.
Can I just say that?
No, actually, we need to hear from Attorney Snyder on this. Please chime in if you can.
Yeah, so in response to Mr. Wilson's motion, so we went back and looked at the NOx.
Well, I think we have the background from the witness, but where is this new report?
It's not a new report. It's just something that PSC ran in response to critiques that witness Carrera had given in her Sir. So I think the proper way
so
to
wait, hang on. So when you filed Sir rebuttal, was this new information provided?
This was evidence.
It's what in evidence? What?
This was evidence that was provided by Corer in Sir. And so we simultaneously filed Sir and didn't have the ability to address it in Sir.
Right. I understand that in terms of that timing.
Yeah.
But in this point, there's new information to be provided in order to rebut Correr's Sir rebuttal. Is that what's happening now?
What happened is that PSC reran the analysis using Corer's Sir, and then has that information, but did not present it because there was no opportunity to present it anymore.
Well, there was. You had the opportunity to present it now when you called your witness.
Okay, so my understanding of the rules would have been that would have been Sir, that we would not have been able to do that because we already submitted Sir rebuttal.
Okay, let's go off the record for a second.
Okay.
You're all right. I have two additional points that I think are relevant here.
Okay, well, okay.
I understand we're off the record and I can make them again on the record.
I'm not going to cut you off. I'm just looking for something and then I'll move on. Yeah.
Your Honor, whenever you're ready, I'll make my 2 points.
Have to wait for me.
Yep, no problem.
That's how these things work. There we go. Took a while. So let's review what we have here. So let's get on the record. So I'm just responding briefly to Attorney Snyder's characterization of the rules of the proceeding that in description was that since the HWC UCS had filed sur rebuttal in writing, there was no further opportunity to offer evidence in response to the last filing or presentation of evidence by another party. So I just wanted to make sure we all understand the rules that we should be operating under. So essentially, the pre-hearing procedures, section F of the FMO, number 6, it states prior to cross-examination, any witness may offer brief oral testimony that responds only to the last round of pre-hearing testimony or subsequent testimony of another witness received at the hearing. Use best efforts in this matter to avoid undue surprise or prejudice. So according to this, what I would have expected the witness to do is that when the witness was called, if there was an additional response to be made for the sur rebuttal that the applicant had filed, it would have come in at that time. And it would have been, essentially would have been offered, I guess, is really the main point. At this point, if someone is going to bring up an answer to cross new testimony about more information that this person has available, I mean, the preference would have been to do that ahead of time. Now, I don't know.
Your Honor, I'm sorry to interrupt.
Yeah, I know you're going to talk. Just a minute. And then using best efforts to avoid undue surprise or prejudice is another consideration here. So whether there's surprise or prejudice is another issue. But let's hear from the applicant on this.
Thank you, Your Honor. Another, I think, relevant consideration here is that the issue here appears to be the fact that Dr. Nunez double counted emissions to some extent and used them as inputs to her model, and specifically around the issue of startup and shutdown emissions. That issue was not first raised in sur rebuttal. That was raised in Corer's rebuttal testimony at page 8. So to wait until now to present a new analysis on that issue is totally improper. And if that's not surprise or prejudice, I don't know what is. Secondly, I would just note that it appeared to me that Dr. Nunez was reading the answer to that last question. And if that written answer was available, at the very least, it should have been presented ahead of time. And it's just not proper to have a witness reading answers to cross on something like this.
Okay, well, I don't.
Can I clarify? Can I clarify a point that was made by Attorney Wilson?
Well, is there something that Attorney Snyder has to add on this?
Yeah, I can jump in here. So, Your Honor, this was not something that we wanted to raise as an issue prior to Dr. Nunez's testimony for the reasons that we just discussed, in terms of this was done in an attempt to avoid undue surprise and everything like that. And I, to clarify, I did not know that this was going to be something that was going to be addressed in this cross-examination testimony. So to Attorney Wilson's second point about the corrections to startup and shutdown emissions, that seems to be a typical correction that would be given as part of testimony. And we realized that issue as it related to Corer's sur, and we figured that out on sur. So if if you'd like, we can go ahead and we can have Dr. Nunez testify to the extent that she's redone it, or we can take whatever corrective action that you feel is appropriate at this point.
May I be heard, Your Honor?
Yeah, go ahead.
The corrective action is to not allow this testimony, which changes the analysis. This isn't the 11th hour, it's the 13th hour. We're in the hearing. And more generally, there's no way that the original report or testimony can be allowed in the record because the witness has admitted that it's wrong.
I would disagree with Mr. Wilson's characterization on that last point. I would say that to the extent that the testimony would be struck here, he has the ability in briefing to impeach it through this record in the hearing.
I don't have the ability to impeach it. I don't have any of the analysis.
You have Cors Sir that says that the NOx controls were not properly implemented into the report. You have testimony.
But there's just been testimony that changes the health impacts and economic analysis. I don't have any of that.
And to the extent that that is a number, we can strike that number if that would be seen as the most.
No, we can't, because then the record is wrong. When Attorney Snyder says he didn't think we were going to get into this on cross, I think what he means is he was hoping it wouldn't come out. I mean, this is just beyond the pale.
Right. Well, I think what we're going to do is strike the numbers from the witness's response in the question and answer. At that point, I think we'll let the rest of the record remain, and the fact that the report may or may not be accurate is in the record, because there is testimony that the NOx emissions were not all calculated correctly. So I think that at least eliminates the issue of prejudice bringing this new information in at this time, and the record stands as it is before, without there being any objections to those filings previously filed or raised. So there is so I think it can still be the validity of the report or the witness's presentation could still be challenged or critiqued based on the certiorari of Correr, but the new information won't be admitted because it's out of time and does cause prejudice. So I think you're going to have to see then, because this is a pretty strange, I think we usually don't actually strike a transcript. What we can at least do is to direct the commission to ignore those numbers. I'll have to decide whether it's appropriate to actually strike the number from the transcript, but either way, the commission won't be able to use that information to base its decision. All right, let's move on.
So you're right, can I just ask one point of clarification as we head into briefing? So I think it's likely that the applicant will want to draw attention to the fact that apparently the numbers in the original PSC report are incorrect. Is it your intent to leave enough on the record or on the transcript of cross here to allow us to make that argument? That's just not clear to me.
I think it's just the number. I think they already admitted, right, that the direct was incorrect, that it used the wrong table. And if we just keep the updated number out of the record, there won't be a new information provided, but the fact that the report may have inaccuracies will still be there.
Thank you, Your Honor. Appreciate that clarification.
Okay. Any more cross?
Yeah, a little bit. Just rearranging a little here. Dr. Nunez, your COBRA analysis relied on you inputting emissions numbers, and then COBRA gives you an analysis of health impacts and economic impacts. Is that right?
Correct.
The emissions that you input into COBRA indicated a increase in overall emissions at the Oak Creek site relative to the status quo, correct?
Can you repeat that question?
Let's read it back.
Thank you.
Question: the emissions that you would input into COBRA indicated an increase in overall emissions at the Oak Creek site relative to the status quo, correct?
We use the emissions reported in the CPCN application. And just to clarify on the discussion about like using the wrong numbers and the wrong outcome, if it's okay for me to clarify a point that was discussed and it wasn't properly captured.
Is this an answer to the question?
No, it's not an answer to that.
No, so there will be an opportunity for redirect. At that point, your attorney can ask you questions about the cross.
Okay. So in the COBRA analysis, we don't have to specify, in that analysis, you don't have to specify whether this is an increase or this is a decrease. You use the emissions that are reported and you do the health and economic impacts of those emissions. COBRA basically estimates changes in air pollution concentration using the emissions that we provide, like the emissions that were reported in the CPCN application. So in terms of whether it is an increase or a decrease, yeah, it compares to a baseline that was before the added emissions.
So your inputs that you used for COBRA reflected an increase to emissions at the Oak Creek site relative to that baseline, correct?
Relative to the baseline, yes.
Based on your understanding of COBRA, if you had entered an emission decrease instead of an emission increase, the COBRA model would have shown reduced health impacts and positive economic impacts, correct?
Yeah, that is correct. And that's what Dr. Hall submitted in her direct testimony. She evaluated the health and economic impacts of the difference in air pollution emissions when comparing the emissions from the proposed natural gas plant to the coal plant.
You included the EPA's user's manual for COBRA as Exhibit Nunez 3, correct?
Yeah, that is correct.
And you're familiar with that user guide and you've referenced it in developing your opinions?
Yes, I am familiar with the user guide.
Could we pull up Nunez 3, please? And specifically page 6, I think it's 6 of the document, not the PDF. Yeah, right at the on this page, the EPA's user guide says that Cobra is a screening tool, right?
Correct. I also mentioned this is also mentioned in the PSE report and in various points in my testimonies.
Would you agree that as a screening tool, the Cobra tool has specific purposes and some limitations?
Yeah, I understand. I'm aware.
That's a yes.
I'm aware that Cobra has uncertainties, and I'm aware that its frame has a screening tool. Yeah, and as a matter of fact, every statistical model has a level of uncertainties. And when you do the Cobra analysis, it provides a low-end estimate of the health and economic impacts and a high-end estimate of the economic impacts to address some of this uncertainty. And in our analysis, we also, in addition to using Cobra, we also use the intervention.
Your answer is not responding to the question I asked. I think the answer to my question was yes. Correct.
Okay, let's move on. Next question.
Could you please go to page 24? Here, there's a list of 6 bullet points, and they're described in the user guide as uncertainty concerning the values of key components of Cobra, right?
Cobra has uncertainty. Are you asking me if the uncertainties come from these components?
Well, would you agree that these 6 things listed here are among the uncertainties in Cobra?
Correct. Yeah, that's what the user manual says. Yes.
And the user manual, toward the bottom of the page there, says users should exercise caution when interpreting the results of the analyses, right?
Yes, correct.
You agree with that statement?
Yes.
You addressed some uncertainties with the tool in your testimony, right?
Yeah, as I was mentioning earlier, we are aware the model has uncertainties, and we are aware that it's a screening tool and we use it as such. And as I was mentioning earlier, Cobra produces like a low-end estimate and a high-end estimate to address some of these uncertainties. And we also run the intervention model for air pollution, which is another model to estimate health and economic impacts. Has a sensitivity analysis also to address some of these uncertainties.
So I'm just going to remind the witness, if you could answer the question, and then if there's additional information, your attorney should be asking you to add that in on redirect. Should your attorney feel like the record is in need to add the additional information in, that's an opportunity that the party has. But at this point, we understand your position on this matter, and we can. If you just answer the questions, then we can revisit whether something needs to be added by you after on redirect. Appreciate us moving along. So let's see if we can try to wrap this up. Any other questions, Attorney Wilson?
I do have further questions, Your Honor.
Okay. How many questions do you have?
I don't know. It depends how long the answers are.
Okay.
Yeah.
Go ahead.
You didn't attempt to reflect Cobra's margin of error in calculating your results in the PSE report, did you?
We reported the low end and the high end values in the report and in the testimony. And yeah.
All right. Cobra's inappropriate for calculating NACs, correct?
We didn't use it to calculate NACs.
Right. And Cobra would be an inappropriate tool to calculate NACs, correct?
Yeah, COBRA should not be used to calculate NACs, and we did not use it to calculate NACs or intended to use it in any regulatory context.
Mhm. Dr. Nunez, it appears from your resume that you have authored some publications pertaining to health effects of air emissions and also on epidemiology, right?
Yeah, yes, that was.
Is it fair to say that you have some familiarity with the academic epidemiological literature in the area of air emissions?
Yes, I study PM 2.5 exposure and neurodegenerative diseases.
Are you aware that COBRA uses 25 epidemiological studies for the health impact functions used to estimate the health? Excuse me, I'll start over. Are you aware that COBRA relies on 25 epidemiological studies to estimate health input functions?
Yeah, COBRA estimates the health and economic impacts for like about 30 or maybe 25 health endpoints. And then there is like epidemiological studies that are utilized to have the concentration response function for each of those health endpoints.
Have you reviewed Dr. Hall's analysis of those 25 epidemiological studies, which is Exhibit Hall 9?
Yeah, I briefly reviewed that exhibit.
Do you dispute that none of the 25 studies applied personal monitoring equipment or even air sampling near enough to measure individual level exposures to PM 2.5 or ozone?
Yes, and many epidemiological studies that evaluate exposure to air pollution don't use exposure devices. That's pretty common. It's not something uniquely faulty to the epidemiological studies that were included in COBRA. And the results from these epidemiological studies, especially as it pertains to premature mortality, are not unique or outliers in any way of the results that we find in the scientific evidence and like the scientific body of PM 2.5 premature mortality as a whole.
I'll go off the record for a second. Attorney Wilson, did you say it was what exhibit was that list of articles?
All 9, I believe.
The 9?
Oh, I'm sorry, 3. Hall 3.
Okay. Okay. Let me just yeah, I was a
Typo.
little scared there for me. We'd be cutting
there's
all
other
kinds of
7
stuff
out,
out of the
right?
record then. Okay.
Exhibits.
Okay, so this is our
That's not it. Hold on. We'll get you the right site in a
I
second.
believe it's Hall 1.
okay, thank you.
I think it's actually 2.
2. Well,
Yeah.
let's try it. I think one's probably the CV, so
Oh,
Yeah,
that's
it's 2.
right. Yeah.
okay.
Sorry
So
about that.
this is this what you were referencing?
Yes, that's it.
Okay, all right. So let's get on the record. So I think I can just say that we've just discovered that our reference to Exhibit Hall 9 that was just laid on the record should be correctly referred to as Exhibit WEPCO Hall 2. All right, thanks. Let's proceed.
Thank you. Apologize for the confusion.
That's right.
Would you agree that the studies used ambient air monitoring at various regional levels and assume that individuals were exposed to those levels?
Yeah, the studies use different methods to evaluate or determine exposure.
So many of these 25 studies are either ecological, cross-sectional, or case crossover studies, correct?
Yeah, that's very common in the epidemiological literature. Yeah.
So as someone who's familiar with the epidemiological literature, is it safe to assume that you're aware that ecological, cross-sectional, and case crossover studies used to support the COBRA health impact functions cannot establish that the exposures to elevated PM 2.5 and ozone levels happened before the alleged health endpoints discussed in those studies?
As I mentioned before, every epidemiological study has limitations, and the results and like the information that these studies include doesn't deviate or it's not unique from what we see in the literature. And also other air quality regulations also use this type of studies to inform their decision making. And I also want to point out that COBRA was extensively reviewed by multiple EPA scientific boards, as well as the National Academy of Science. So I wouldn't expect those scientific bodies to approve the tool for public use if it was so faulty and producing completely inaccurate and incorrect results. I agree that it's a screening tool, and we are using it as such, but I believe that the epidemiological studies that were included in COBRA are valid. Yes, they have limitations as any other study, but when you compare it to the rest of the epidemiological literature, they're not outliers and they don't show distinct or unique results.
Several of the studies were geographically limited, meaning that the data may not be representative of populations across the United States, right?
Yeah, the studies were performed in different places. Yes, I agree.
Have you read all 25 studies?
I have reviewed some of them, but I haven't read all of them in careful detail. Yeah. Yeah, it will be impossible.
I asked at the top of your testimony, and I believe you said that your position is that the Wisconsin Public Service Commission should reject the CPCN application for the Oak Creek CT project, correct?
Based on the results of my analysis, we evaluated the health and economic impacts associated with the proposed gas-fired plant. Based on our results, there will be health and economic impacts, and I made my recommendation based on that evidence.
Is it your position that Wisconsin Electric should pursue only renewable resources in place of the Oak Creek CT project?
That is outside my expertise. I am not an energy modeler.
Have you analyzed the potential harm to public health or economic impacts that would result if the OCCT project were not approved?
That was not the focus of my study, of my testimony, and I have not analyzed that.
All right, no, nothing further.
Okay. Any other cross for this witness? Okay, redirect.
No redirect.
Okay. Thanks very much. You're excused.
Thank you.
Okay. So we still have some time to squeeze in some more people here. So renew, were we going to call witness Cal?
Yes, Your Honor. Would it be okay to just quickly affirm Mr. Kell's testimony while he's here?
We can bring him, we can call him and we'll see what happens, but we're not expecting anything else but that.
Okay.
So let me adjust our screen, my screen here, go off the record. Okay, I'm going to need pinned and okay, got both of you up here. Excellent. All right, great. So I'll swear you in, witness Cal. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, let's proceed.
Good afternoon, Mr. Kell. Would you please state your name for the record?
My name is Andrew Kell.
Are you the same Andrew Kell who filed or caused to be filed direct testimony, rebuttal testimony, and 2 exhibits?
Yes, I am.
Are those documents complete, correct, and truthful to the best of your knowledge?
Yes, they are.
Do you have any corrections to make?
No, not at this time.
Thank you, Your Honor. Mr. Kell is ready for us.
All right. Any cross? No? Thanks very much. You're excused.
Thanks, Your Honor.
Right. So I think for witness Pilo, we had no questions. We'll take that testimony by affidavit. Is that still valid?
That's my understanding, yes, Your Honor.
So we have witness Carlson next. Attorney Frank and witness Carlson. There we go. All right, you'll need to unmute. There we go. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead, Attorney Frank.
Thank you, Your Honor. Good afternoon, Ms. Carlson. You're kind of at the back end of the witness list again, but here we are. Could you state your name and spell your last name for the record?
Yes, my name is Allison Carlson, Carlson.
And did you submit direct testimony and surrebuttal testimony in this proceeding along with 25 exhibits?
I did.
And to the best of your knowledge, is that testimony and are the exhibits accurate and truthful?
Yes, yeah, no substantive changes that would require a correction, although I would like to note that since I submitted testimony, we have 26 local government members now rather than 23. City of Monroe, City of Monona, and Greene County have joined as well.
All right, thank you. And other than that, if I asked you all the questions that were asked in your testimony and your direct and your surrebuttal, would you answer those questions the same today?
Yes, I would.
Your Honor, just a point of clarification. Can you give some guidance on whether we need to refile the testimony, or can we just have this noted on the record as it's been noted today that there are 3 additional members of Wisconsin Local Government Climate Coalition?
Right. I'll consider that additional testimony you just gave on the stand. At the time of filing, your testimony was correct, and it doesn't really warrant a refiling, that certain change.
Okay, thank you, Your Honor. With that, Your Honor, the witness is available for cross-examination.
Okay, I think the applicant had some questions. Is that correct?
That's correct, Your Honor. Good afternoon, Ms. Carlson. My name is Lauren Rasso, and I'm one of the attorneys who represents the applicant, Wisconsin Electric, in this proceeding. It's nice to meet you.
You too.
Ms. Carlson, your testimony discusses the Focus on Energy program, right?
Right.
And you understand that that's a statewide program.
I do.
Utility contributions to Focus are set by statute, right?
Yes.
And in your direct testimony, you acknowledge that Focus on Energy spending is capped at 1.2% of utility operating revenues, right?
It is listed in statute that utilities must contribute 1.2% of operating revenues. That doesn't bar them from contributing additionally or running their own programs, as I expand upon in my testimony.
But the legislature does set the funding obligations for utilities to Focus on Energy, right?
Yes, the minimum obligations.
You'd agree that utilities do not control how their contributions to Focus are used, right?
Yes.
Nor where they are directed within the state of Wisconsin.
Right, yes.
You'd also agree that the goal of Focus on Energy is not to offset a specific utility's peak demand. Is that right?
I'm sorry, could you repeat that question just so I'm sure I understand it?
Let's read it back.
Oops. Question, you also agree that the goal of focus on energy is not to offset a specific utility's peak demand. Is that right?
Yes, that's right.
Focus on energy does not guarantee that by contributing to the program, a utility will achieve any specific amount of savings. Is that right?
Yes.
Is it your position that energy efficiency and demand response programs are potential alternatives to this project?
They are alternatives that could be part of a portfolio of solutions.
You'd agree that energy efficiency programs or the effectiveness of those programs depend on customer participation, right?
Yes, in the way that the customer's ultimate participation is basically the endpoint of the customer journey. There are many points well before that the utility or program administrator has control to be able to influence that customer's participation.
So a utility can try to get customers to participate, right?
Yes.
But they can't require customers to do so.
No, they can't require, but as I mentioned, there are multiple points before that point of final decision where they can influence that customer and reduce barriers to facilitate participation.
And just like a utility, the commission cannot require customers to participate in energy efficiency programs either, correct?
No, but they also have a hand in reviewing program designs and ultimately approving them.
Utilities cannot require customers to participate in demand response programs, can they?
Correct, although the same factors apply for demand response programs, as I mentioned, in energy efficiency and those multiple points where the utility can have an influence over participation.
But the ultimate choice is the customers, right?
Yes, for that one point in the customer journey.
Okay, and the commission cannot require customers to participate in demand response programs, can it?
Yes, and my same comments as I mentioned in surrounding energy efficiency apply to demand response as well.
Okay, I'm not sure if the commission cannot require customers to participate in demand response programs. Is that right?
Yes, that's correct.
Okay. Thank you. That's all I have for you.
Thank you.
All right. Thanks very much. Any other cross? No, redirect?
No, Your Honor.
I did have one more question for you. Witness Carlson, I think I asked you this in the 316 case. You're not an attorney, are you?
No, I am not.
Okay, thanks. So based on that, let me ask any other questions. No. Okay, great. Thank you. All right, you're excused. And we need to do PSC staff and DNR witnesses. So who are we calling next?
The commission calls Jordan Munson to the stand.
Can we take just 5 minutes?
Yes. Why don't we do that? We'll give you 10. So
I don't need 10.
Don't need 10. All right. Well, 2:30. How about that? I'll give you 6 minutes.
Thanks.
Back at 2:30. Thanks.
Sorry for the interruption, Stephanie.
No worries.
I had to change my shirt yet again. I have ice on my back and it keeps leaking. So I freeze because the back of my shirts are wet.
You don't want that to happen.
No, it has 3 times, but I don't think I've ever seen you with your hair down. Look good.
Thank you.
All right. So we're here to take staff witnesses. It's now 2:30. Gonna add. I'm adding Attorney Bedford to my screen. Do we have witness Munson?
I'm here.
Oh, there we go. Excellent. All right. So let's get back on the record. I'm going to swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you. All right. Go ahead, Attorney Bedford.
Thank you. Please state your name for the record.
My name is Jordan Munson.
And what is your position at the Wisconsin Department of Natural Resources?
I am an air management engineer.
And did you file or cause to be filed direct testimony in this docket?
Yes.
Are the statements and representations in the testimony you filed in this case true and correct?
Yes.
And do you have any additions or modifications to your testimony at this time?
No.
Thank you. Your Honor, the witness is available for cross.
Any questions for this witness?
Yes, Your Honor. Sierra Club has a very brief cross.
Okay. Let me grab your you to my screen here. Okay, welcome. So just introduce yourself to the witness and go ahead with your questions.
Thank you. Hello, Mr. Munson. My name is Megan Walkspress. I'm an attorney with the Sierra Club. It's nice to meet you.
Yeah, good afternoon.
So the permit, you are responsible in part for preparing the air permit associated with the Oak Creek CT facility. Is that correct?
Correct.
And that proposed permit incorporates as part of its emission sources the 2 billion cubic foot LNG facility that is being considered by the PSC in a separate docket. Is that correct?
Correct.
And the environmental assessment prepared for the Oak Creek CT project did not include any assessment of the environmental impacts associated with the LNG facility being considered in the separate docket. Is that also correct?
Not necessarily. They are for the air program and the DNR. The two projects are very, very challenging to pull apart. And so our analyses really looks at them quite separately. But we tried to distinguish them as much as we could for this process.
But they were not distinguished for purposes of the air permitting process. Is that correct?
For the purposes of air permitting, they are one and the same project.
But for purposes of the WEPA analysis, they were treated as distinct.
As part of the PSC process, we had to treat them separately.
Okay, thank you. I'm all done, Your Honor.
Okay, I'm just trying to digest that. All right. Any other cross from the witness for the witness? Nothing? Redirect?
No redirect, Your Honor.
All right. Thanks very much. You're excused.
Thank you.
The commission calls Jury Rademacher to the stand.
All right. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
Yes.
All right. Go ahead.
Please state your name for the record.
Jury Rademacher.
And what is your position at the Wisconsin Department of Natural Resources?
I am a water management specialist.
And did you file or cause to be filed direct testimony in this docket?
Yes, I did.
Are the statements and representations in the testimony you filed in this docket true and correct?
Yes, they are.
And do you have any additions or modifications to your testimony at this time?
I do not.
Your Honor, this witness is available for cross-examination.
Any questions? No? All right. Thanks very much. You're excused.
Thank you.
Thank you. And lastly, the commission calls Stacy Rowe to the stand.
Well, raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
Go ahead.
Please state your name for the record.
Stacy Rowe.
And what is your position at the Wisconsin Department of Natural Resources?
I am an endangered resources utility liaison.
And did you file or cause to be filed direct testimony in this docket?
Yes, I did.
Are the statements and representation in the testimony you filed in this docket true and correct?
Yes, they are.
Thank you. And do you have any additions or modifications to your testimony at this time?
No, I do not.
Thank you. Your Honor, the witness is available for cross-examination.
All right. Any questions? No one? All right. Thanks very much. You're excused.
Thank you.
It's all of the staff witnesses. So I think we have all of our witnesses checked in. We'll just be expecting affidavits from, what's her? Well, there's a few, yeah. I'm not going to try to figure that out right now, but we have everyone checked in. We're just be awaiting verification from some, and we have our post-hearing schedules already set. We'll be expecting refilings and a few new filings that we've discussed during the course of the hearing. That's all due in 3. So, okay, this is. I'm glad I was thinking this through while I was talking. So the deadlines, can actually discuss this. So we did push the hearing date out one day here. So the deadlines, I can give people an extra day for refiling, and for the draft transcript will be out a day late compared to the original schedule. So we can push all of the deadlines for the post-hearing filings can be pushed one day out, and the transcript corrections process will be pushed one day out. I'm wondering, though, if I could get comments on whether the brief deadlines need to be pushed out or if we can keep those as they are. So I guess someone wants to start that discussion, just go ahead.
Your Honor.
Yes, who's that?
Lauren Rosso for the applicant.
Great.
From
Go
our
ahead.
perspective, the briefing deadlines are sufficiently far out that we do not request an extension.
Okay, does anyone else want to comment on that? No? All right. So like I said, I'll be making adjustments to the online calendar to reflect this changes, but there won't be anything else issued. Just count 1 working day extra for, what did I say, the post-hearing filings and the and all the transcript process. So the draft transcript, proposed corrections, and objections to proposed corrections. Okay. All right. Anything else we need to address? Okay, we'll be meeting. We'll be inviting the public to our public hearing session on March 25th. So we'll be happy to take public testimony at that time, and the written comments, public written comments, are due March 25th, March 27th. Sorry. So with that, I think that's all we need to do here. Thanks very much, everyone, and we're adjourned. Take care.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.